Well, we are live now. Good morning, members of the #1 committee, the Joint Judiciary Committee. It's great to see you again on our second day of our second meeting of the interim. So we'll go ahead and get started. Mary Beth, would you like to do roll call? I know it's the second day, but it's hard to see who's here and who's not on the Zoom as people keep coming in and out, and it's just kind of helpful to hear that verbally.
Senator Anselmi Dalton.
Present.
Senator Boner.
Here.
Senator Cos.
Here.
Senator Von Flatern.
Here.
Representative Burlingame.
She is excused.
Representative Gray.
Here.
Representative Jennings.
Here.
Representative Pelkey.
He's here.
Representative Parnell.
Here.
Representative Salazar.
Here.
Representative Stith.
Here.
Representative Washut.
Here.
Co-Chairman Kirkbride.
Here, and Representative Burlingame called to say that she would be a bit late.
Okay. Co-Chairman Nethercott.
Here. All right, thank you. We'll go ahead and get started with the first item on our agenda, which is the Wyoming Courts and Supreme Court updates, a friendly topic of which we're familiar with. This first item on the agenda is the e-filing informational review. Case filing and statutes. I know there's a working group associated with the Supreme Court that they have created to really get e-filing underway, and they would like to provide us just a broad overview and an informational update. So as we let those folks in, we'll go ahead and get that update.
Chairman Nethercott, if I may, real quick, while we do that, I just wanted to introduce to the committee our new staff attorney, Elliot Browning, who comes to us. He's a recent graduate of the University of Colorado Law School. He started Monday, took the bar exam last month in these crazy times, and we're glad to have him and just wanted to introduce him real quick to the committee.
Good morning, everyone. Like Brian said, I'm Elliot Browning, and this is my first week here at the LSO. Look forward to working with all of you.
Well, welcome, Mr. Browning. We're excited to have you, your staff to the best committee, the #1 committee. So this morning when I first saw him and he came on before we went live, I knew immediately he was a lawyer just by his sharp look. So welcome. You're a good fit and welcome to. We need the help. So with that, I think, do we have everybody? Looks like we've got former Representative Nicholas or Senator Nicholas. I'm familiar with Representative Nicholas. Good to see you. So we'll start with the former Senate President, Phil Nicholas, who has been still working hard and serving the state, particularly on this issue. So whenever you're ready, Mr. Nicholas, please go ahead and fill us in.
Well, Chairman Nethercott, thank you very much for having us. And of course, I was a former House Rep member too, so I've been on both sides, both work. We asked to meet with you this morning to talk to you a little bit about the court's program to get to electronic filing. For the lawyers on the committee, you'll know that in the federal system that you can e-file your documents, and you can e-file in Colorado and many states. When I was on the House Appropriations Committee years ago, we really, that was when we began asking the courts and working with the courts to develop their system of e-filing for a lot of different reasons. One, for the convenience of clients, lawyers, and the community, but also to provide, as part of our initiative at the state, to get all public records electronically filed. The process for getting e-filing in Wyoming has been, it's true for all states, but it's difficult. First, you have to get a case management system where all of the clerks, the district court clerks around the state and the circuit courts are all on a case management system where they can, all the data gets entered, and only after you can get the case management system up and going can you then take that information and put it into an e-file system. The lawyers on the committee know that at the Supreme Court, you can, for several years now, you can e-file, and it's a great help to citizens. It's a great help to the users of the system. We're working on district courts and circuit courts. Today on the meeting, I'm the chairman of a committee called the Court Records Division of the e-file committee. Justice Gray is on the Zoom call. She is the Supreme Court justice that is assigned to this part of the initiative. Tina Wood, I think, should also be on. Tina is the clerk of the district court for Sundance, living in Sundance, but for Crook County. And also, you should know, on the committee that I'm chairing, Senators Dalton and Senator Ellis are also on that committee. Generally, our task is this, and the reason why we're here is because the task that this subcommittee is asked to perform is going to require your help. And I'm really here to talk about your help. And better yet, what I'm really asking is that Brian Fuller do a lot of work next year. And Brian doesn't know that, but I talked to Matt Obrecht yesterday, and we're trying to figure out how to staff this. But let me talk to you about what we expect to happen and what it is that we're to perform. Before we can go to e-filing, we have to know, and the clerks of the district courts and the circuit courts have to know, what information that gets loaded into the system is available to the public. And that is, some information is private, some information goes to lawyers, some doesn't go to lawyers, all of it generally goes to the judge, but somebody has to regulate and determine what documents get filed and are public. And to accomplish that, we first have to go through each statute, and we expect that there's going to be hundreds of statutes. We know there are, and it's going to be a big lift, but you go through each statute and you determine, all right, for this juvenile record, who gets it, who doesn't get it, and how do you protect it? But the first determination has to be who gets it. So this process of trying to make this determination began probably 10 years ago. I served on a committee with the courts, and we met for a year and accomplished really very little. So I agreed to chair this committee, and we kind of take a different approach. We said, look, what I'm going to do is ask the Supreme Court staff to go through each statute and make a recommendation of privacy level. The committee will vote on each recommendation and will either accept or reject it. But at the end, we will complete a matrix. It's going to probably be 10 or 15 pages long, dealing with hundreds of statutes and making a recommendation for each record, who gets it and who receives it. Also on the committee, we have a representative from the press. We have Bruce Motes, who is really focused on making sure that there's public access. It's a pretty broad committee to make sure that everyone is represented. Once we create the matrix, then that is the template for modifying the statutes. So we're going to have to go back through the statutes, because our statutes as they exist right now just don't contemplate that we're going to have electronic filing. And so we began to look at what the lift is, what's the load for that statute. We asked Dave Gruber to take a look at it, and what he determined is that it's going to be a full interim work for somebody to complete. Dave has met with Matt Obrecht. We've met with Matt Lilly and Sharp, who you know is with the courts, and Elisa Butler is also doing some of the work with us, or doing the work for us. We've all met with them, and we think that you've got really two choices that we want to talk to you about. And I don't think you have to make a determination today, what I envision is we'll make this determination when you do during the session, when you sit to look down and try to figure out your workload for interim work, except that I'll talk about the question of whether we ought to have a task force. But in general, what it's going to involve is going through each of the statutes. We think the bill is probably going to be an inch thick bill, and it's not going to be a terribly complicated bill, but it's going to have to change words in each statute. It's one of those bills that becomes a trust me bill, where you go through and you can see that on every statute there's a couple changes, but the work is going to be substantial, and we think it needs to be a legislative product. We can provide, or the courts can provide, some help to get there, and they've already begun that process, but in the end it's got to be your product. And so what we're going to ask you to do is make it part of your interim work and assign it to your staff to do the bill, and then that bill would come back in the following year for adoption. Between now and the session, Chairman Nethercott, I think we'd like to meet with your staff as well as the co-chairs to really talk about whether or not this is in fact something that you would like to add to your interim list of topics to do. And I think you can do it, or whether you'd like to assign it to a task force, which of course would require some legislation to be presented. My personal opinion, having looked at it, is I think it's something that you can do fairly easily as interim work, that you could just add it to your interim topics. We will have a fairly thorough template, or I call it a matrix showing all the statutes that are going to be required to be amended, and the privacy levels. If we make mistakes on the matrix, we can change it. But we've got to get the matrix completed in order to give everyone the security to know that we can go live with the e-filing system, which is probably going to be about 1.5 to 2 years from now. If you're a clerk of the district court, you're going to be the frontline person that's going to hear objections if someone's private records, their social security numbers, their information about their child, gets inadvertently placed on the internet. And one of the reasons why we've had resistance from the clerks in getting to the e-filing system is they just can't see or have assurances that the information that they're responsible for collecting is going to be private where it's necessary, and they know that they're going to be the brunt of these criticisms. So we have Tina Woods as part of the committee to make sure that the clerks are satisfied with the result, and then ultimately you'll have the legislative package where there'll be the legislature will be able to participate. Chairman Nethercott, I think that sort of introduces the topic. We don't really need for you to make a decision. We do want to be a partner with the legislature, and we would like to ask you to help us in beginning after your first session. I did want Justice Gray just to talk to you a little bit about the court's efforts and what they're doing, and the timeline to get this project online.
Well, thank you, Mr. Nicholas. I appreciate you being here today, and I appreciate your efforts in taking up this issue and taking the lead. I know it's been very frustrating to me as a practitioner. I'm sure you have heard about some of those frustrations for the lack of progress on e-filing and the different promises made about when that would be available to Wyoming citizens and attorneys and the courts. As a result of that, I mean, the different deadlines that have been presented, when I first was elected and started addressing this issue, I too was concerned about the lack of progress when it came to what documents and pleadings should be confidential, and that there was really no guidance as to that. Had a private working group at that time with the court, heard from former legislators who had worked on the issue as well. And I think that the program that the court purchased did not have the ability to file confidential documents or really any ability to limit or have that capacity. And so that was the direction, and the, words of transparency were dropped. But I expressed severe reservation about some of those documents really are confidential by rule, of which lawyers are used to practicing with, and then by good measure that some of those confidential documents concerning children need to be protected in other ways. And so a more robust conversation from the court, I thought, was important. I do understand the court's unwillingness to kind of drive that conversation because some of those really are policy oriented. So I am curious to see the matrix that will be presented from this working group, and how some of those policy questions may be identified that really would be within the judiciary to make a decision at the legislative level, as opposed to kind of the technical requirements associated with broad statutory changes that you're discussing. Leadership has told us that task forces are discouraged, and we're trying to reduce the number of legislative task forces. And in light of the conversation that you have shared, that really you don't think it's that difficult, I don't know that a task force would be the right course, and we appreciate the work that you will be able to provide. And certainly we can review that. I am excited to hear that within the next 1.5 to 2 years, there'll be a case management system. And so the need to have these rules and statutes in place are important with that time frame in mind. We have heard recently that e-filing wouldn't be available probably for another decade. Is that your understanding as well?
If it is, my partner is going to choke me down the hallway. My understanding is that, Chairman, I think I can share a screen. Let me show you what our, I think your staff has to enable me to share the screen, and I could show you a timeline. And if they would do that, I'll show it to you. Can they do that? Or maybe we can't do that with our technology.
Madam Chairwoman, the screen share is enabled.
All right, thank you. Let me, I've got too many things up on my screen. I've got to get the right one here.
So as you do that, I'm going to let Representative Parnell ask a question.
Thank you, Madam Chair. Yeah, I've been a little perplexed on this e-filing. It's been talked about since my days, even as sheriff, which was 6 years ago. And it's taken quite a bit of time. But my understanding is, I guess a question is, there's already a standard for the clerks of the district court on the information they release. So I'm a little confused as why that's going to be an issue as far as trying to make sure that that's put into the into statute or amend those statutes. I thought that it was pretty clear at this point when they folks go into their office to ask for records and so forth, what they can and can't release. So I guess that's kind of my question. Why is it so entailing into the statutes?
Mr. Nicholas, if you can.
I can answer that. I mean, if I get my screen share, I could actually show you an example of a couple statutes that will help you. But when you think about your statutes, if you were to go through and look at it, you'd realize pretty quickly that our statutes don't actually contemplate that documents will be electronically filed. They say, well, you're going to file with the clerk of court, you're going to file in the court record. And there's a number of statutes. First, if you have to authorize the electronic filing of the system and the sharing. And I'm doing two things at once here, I apologize. But each statute tells you where the document goes, what happens to the documents, whether it goes into a sealed record. So a lot of the compliance is simply trying to get the statutes to recognize that now the official record is going to be an electronic record. It's not going to be a paper file in the clerk's office. And so there's a lot of that. And it's really not difficult, but it has to be done. It's just sort of nitpicking each statute to go through. And what I'm seeing here is I'm not sure that the document, for some reason, I'm not be able to share the template. Let me turn it over to Judge Justice Gray, and while she's just giving an introduction about some of their timelines, I'll get this thing shared.
Mr. Nicholas, if you want to just email it to the committee.
Oh,
too.
there it is. I found it. I
All
think
right.
I've got it.
In the meantime, before we turn to Justice Gray, we'll go ahead and hear from Representative Stith.
Madam Chairman, thank you so much. Mr. Nicholas, question here. I think you've already said this, but it sounds like you're talking about just compiling the list of statutes that already exist with respect to confidentiality. And so, for example, Rule 6 of the rules governing access to court records provide a list of 37 statutes that provide for confidential information. So is the task you're describing just limited to compiling these and then making sure that it's making any adjustments if necessary for electronic records? Or do you see your task as more expansive to actually change the privacy classification?
Mr. Nicholas.
Well, I think, can you all see now my shared screen?
Yes.
All right, so this is an example, Representative Sith, where you have a variety of statutes here. The first one is 14.2.815, only final judgment available without court order. And so then the question is it who gets access to it? Also, over on the right side, does the judge get, that's 1, 2, 3, 5, 6, and 7. So the judge can have access, the custodian can have access, the filing party has to have access, the agency has to have access, interested parties, and public. So you have 7 categories of folks who may want to have access. And then it may be that some people get full access, some people get limited access, and some have no access with court order, or some have no access under request. So this is the matrix that we'll be voting on. And what you can see here is that for each one of these statutes, there's information that will be built into, that is actually part of the court record. As you know, it's somewhere in the court record, but that doesn't mean that it ought to be exposed to the public. It ought to be in the court system. Somebody ought to be able to see it. So this matrix has to be developed for each statute in order for the software people that are doing the e-filing system to know how to implement it and design the software. So then when you go to look at the statutes, let me see if I can just pull down an example. So here's an example of the kind of statutory changes that I see that you're going to be making. This one just happens to be classification of protected court records. And I'm just going to go through and just show you where some of the changes are. The court records shall constitute a protected file under the statute. And so where it uses all of the file, now we have papers and records. We're going to jump down to starting to see changes here where you have protection requirements for your e-filing system. Where we have confidentiality, we're going to end up having to change that word to a common word that's protected court records. We have a number of statutes that are just going to need to be these are the types of changes that I would say are more conforming changes. They're to conform what we do now to an electronic system. But what we see, and when we asked Dave Gruber to go look through, he sees that, look, to meet your constitutional requirements, to make sure that the legislature does its part, you're going to have to go through something like 20 codes to make conforming changes to your electronic system. And it's a tedious job, but not complicated. And so this is the kind of bill that if you're dealing with 20 codes, so here, just something, identifying information shall be protected pursuant to the statute that deals with e-filing. So to deal with this, what I think is you're going to have a pretty substantial bill that comes in, and it's going to be a trust me bill. But it's going to take quite a bit of work. And one of the first questions is, do we need to hire outside help? And the court does have a budget that they could help contribute to additional staff person. But I think talking to Matt Obrecht as of yesterday, he thinks your staff can manage it. And if it turns out they can't, then the court is prepared to help and do that. Now, the question that Senator Nethercott, Chairman Nethercott asked, now here is the current schedule of work. And so what you have is the e-filing pilot online in 2022. The work that we're doing is in lines 3 and 4, which is the developing the legislation needed to implement it and do the privacy work. So, I mean,
Mr. Nicholas, can I just
yes.
ask a question right now? So, you know, I appreciate that now we need legislative action to do the work, but isn't it true?
Yeah.
That you could continue developing the system, recognizing that there's going to probably be very few policy questions for the legislature to consider. And really what we're doing is just amending the current statute to recognize there's an e-filing system, but there will be some policy questions, but very few. And so the work can still continue regardless of this bill.
Absolutely. The Chairman, if you look at the work that's being done now that's delaying the so there's, and Lily might be the best person to come on and talk, or maybe even Justice Gray, but a vendor has been selected now for the e-filing system. And what has happened is we have now agreed, or all the district courts, the clerks of the district court have now agreed to a uniform case management system. So we are in the process of now migrating all of the information to a case management system, which will be fully developed. And then the e-filing system comes online. So all this work is happening together. It's not as though we're doing one thing, then the other thing. We will bring the e-filing people into our subcommittee in the next meeting, having them tell us what they need. So my question to the e-filing folks is, tell me what it is you need to make sure that you can get your software up and running. We need to do that. And so our task is to be ready for them, but they'll be developing their product and getting the e-filing system while we are operating.
Looks like we have a question from Representative Pelkey.
Good morning. You know, I've followed this for quite a while myself, both as an attorney and as a legislator. This whole process has been in fits and starts. Didn't we have a system in place that we ultimately had to abandon? And if so, can you give me a little bit of history on that?
Representative Pelkey, that's true. We had the first case management software that was employed did not work successfully. It had severe limitations, and they've now shifted. And I'm not going to kick out the names of the vendors, but in general, you're correct. But you know, look, folks, nobody's more frustrated than I am. While I was sitting in your positions, I pushed this. It was back when I was in the House, so it's more than 13 years ago, and we have come a long way. But I'll also tell you that as chairing the Appropriations Committee for many years, every agency that we have asked to go online has had these same starts. For those of you that have been on labor, we spent almost somewhere between 40 and 80 million dollars on a program to put Department of Health in to get their documents electronically filed. And that entire $80 million was a wash because the vendor didn't deliver at the end. It was a Medicaid expense, and we said, well, let's move on. If you look at the state engineer, we had false starts. We started something that didn't work. We finally got it. The same is true for DEQ. We had massive false starts. We would start something, we'd pay substantial monies. And, you know, it's, as one of somebody told me with respect to construction, it's a messy business. And it seems to be the same true for software development. It's a messy task. And if you look at the false starts and the costs that the courts have incurred, they're not out of line with every other agency that I've seen trying to get this record keeping system going. Now, you also have to recognize that we have budgets to deal with. You know that. And you could throw more money into this, and maybe we could have gotten this system further along. It is frustrating for a lawyer, as I am and as you are, to know that I can e-file with LexisNexis in Colorado. I can e-file, and then they merge to their own system, which they have. I can file with the federal courts, but here I can't do it in Wyoming. But if you look behind the money that's spent by the feds for the PACER system and for the ECM that they have now, they're monstrous amounts of money, and we have never committed those kind of resources. If you look at what Colorado has spent, they're now in their third evolution of systems for e-filing, and they're now migrating to a brand new system. So what I would tell you is I'm confident at least that the current staff have a good handle on it. They do now have a plan. I'm frustrated along with everybody else, and I think they're frustrated too that they can't get it sooner. But we adore our district clerks of district courts. They're independent people. When we began this, there were 23 counties with different systems, and we've come a long way. And it really doesn't make any difference how we got here. At least now we have a plan to get there. But in order to get there, to do the finish point, we need to have these records properly classified to protect the clerks' district courts, or else they're not going to support it. And we need their support. And we need the legislature, I use the word we, the legislature needs to do its part to do the statutes. But that shouldn't stall or stop the development and the completion of the case management system and the e-filing system. And as I said, the e-filing contract has now been, we have a vendor and we're moving through there. And the court staff are better apt to tell you exactly what the elements are than I am.
Mr. Nicholas, thank you. Just real briefly, because this has been kind of a surprise to me. I know the district court clerks are concerned about confidentiality of documents, and I'm glad to hear that. I guess I'm frustrated as an attorney is that I'm ultimately responsible for what I submit to the court. And if I submit something in violation of the rules or unlawfully, that's on me and not the clerk of the district court. And interestingly enough, I mean, just recently I've had a couple of, I've moved to strike a couple of documents that were submitted to the court in violation of the confidentiality rules. You know, and the clerks of court didn't prohibit the filing of those documents. They're still in the public record. They haven't, you know, no action has been taken to prevent the unlawful submission of paper copies of documents. So why is it any different electronically, or why is the concern higher?
Oh, Chairman Nethercott, I don't mean to say that the concern is any different. I'm just simply saying that when we go into the development of the software has to have a code, and it needs to know how things are going to be treated. And when you look at this, the sheet that's up on the screen, this is the kind of information that has to be developed. So if I go back to the matrix, the software developer needs a product something like this. The software people are not going to be attorneys. They're not going to be experts in the area. So our statutes are unique to us, and each statute needs to have a classification. So this work enables the software developers to know how to do the triggers, but the responsibility will be on who the filer is. So as you know, when you file a federal court pleading today, the first thing you do is you check a box that says you've redacted your information. You know that you're not putting any social security numbers on the public web. You know, you understand the system, and so you're correct. The filer, whether it be an attorney or DFS or whoever files the documents, they'll be the ones required to check the box and say it's correct. But what my experience does tell me is that when something goes bad and somebody has the information and they find it's on the website, the clerks of district court believe that they're going to get the brunt of it. So the clerks of district court, I don't think are going to frustrate it. They just need to know that we've attended to this part and that the work has been done, which is the work of this committee.
Looks like we have a question from Senator Anselmi Dalton.
Thank you, Madam Chair. I am serving on this committee, and it's interesting work for me. I just wanted to ask, I don't know if I did when we had the first initial meeting, it was sort of a get together, figure out what we're looking at meeting. And I think that Mr. Nicholas, I'm just asking you, you had said originally here on the implementation, you said that it was going to be done in district courts and the circuit courts, but in the memo I have from Lily Sharp, it says it is not, there's no current plan to implement e-filing in the circuit courts at all. And I'm just wondering why that is the case, or if that is the case, or what's happening there. And second, I'd just like to let people know that one of the things that they were looking at to clean up was saying things like sealed. You know, I think they have things like confidential, sealed, secret, all being used sort of generically the same. So that was one of the things they wanted us to look at. And in addition, on that chart that he's showing you, number 4 is missing on it, and that's the non-filing party, if you're interested. So at some point, we probably should correct the chart to add number 4 as the non-filing party for privacy concerns. And we did get a memo from Ms. Sharp, and I thought it was helpful, and I don't know if the committee can have access to that. Mr. Nicholas, I'm happy to, I think I have the flash drive, and I might be able to share it to people, or Ms. Sharp might be able to email it to the committee.
That'd be great. And Madam Chairman, if Lily's on, I think maybe we just ask her to answer that question.
Ms. Sharp? Ms. Sharp, Lily, are you available?
Yes, can you hear me now?
Yes, thank you.
Hear and see me? Good morning, members of the committee. Good morning, Chairman. That's a good question. Right now, there are not plans to e-file into circuit court, but we have had requests from the circuit court bench to consider that because we could do e-filing in circuit court sooner than the district court, since the case management system will be fully rolled out, we hope, by the end of this year, or at least the first quarter of next year. So that is under consideration, and that will have to go through. We have a court automation committee that will consider that, and then the Supreme Court will be the final decision maker as to whether or not we would start e-filing in the circuit court. One of the things that was important for the district court judges and the Supreme Court is that if we were to do so, that it would not delay e-filing in the district courts.
Any follow-up, Senator Anselmi Dalton?
Yes, thank you, Madam Chair. So I don't know why there were no thoughts. I guess I still don't understand why there aren't any thoughts to put it in there at all. It seems like we want e-filing all over, but I don't file in court, so I don't know. But Lily, could you just be a little bit more? I mean, is it?
I apologize, Senator Anselmi Dalton. I didn't hear the whole question.
I apologize. The question is, I just don't know really what the reason is that we're not considering the circuit courts. Is it because they don't want it to be? Are they resisting it because they don't want to change their systems, or is it just because of the cost? I mean, to me, I don't file into court barely ever. I have done some, but I'm just wondering why we're not doing it. Can you also share your memo, or would you be willing to share your memo to the committee about the history that you gave us on July 28th as well?
Madam Chairman, Senator Anselmi Dalton, we'd be happy to share that memo. And the only reason for not going to the circuit courts first is the only reason that we would have is we have to consider the cost, because we haven't contracted for that yet. And we don't want it to delay e-filing in the district court. Those are the only two reasons, but we are definitely considering it right now.
Okay, Mr. Nicholas, if you could stop screen sharing so we can go back and see everyone. It's easier for me to see the committee that way. And then looks like Representative Gray has a question, so we'll go to him next.
Thank you, Madam Chairman. So I just want to go back a little bit in the history here. We got quite a bit of testimony at the beginning of the current term in early 2019 and in the general session there, that this was being rolled out. And that was my understanding as of 8:45 of this morning, that e-filing was being rolled out. And I thought initially when you were talking about this was a different segment of it or whatever, but now we get this kind of 35 minutes ago, this notion that everything from 2019 has been abandoned, I guess. And I want to confirm that, one, that is true. And with all due respect to Mr. Nicholas, I do think the past is important. I do think legislative oversight is the most, if not one of the top 2 or 3 most important roles of the committee. So from that end, I'd like to know who made this decision. I assume it's the judiciary, but was it the committee? Was there a vote to totally abandon the system? What are the reasons why it was, I guess, a systematic and total failure when rolled out? And then does appropriations know why? What was the process of informing the legislature? Because I don't recall that ever being brought up to the committee. And I guess then finally a more conceptual question, which is, I mean, if this is totally going to be handled by the judiciary, I mean, what, and the legislature just keeps giving funds out to this. I mean, what controls are there from an oversight side? So those are my questions here. Thank you.
Madam Chair,
Mr. Nicholas, I think if it'd be helpful too, I think it's important for the committee to hear the court automation fee, when that was created, because I think that's all those funds were intended to go to this purpose and other purposes associated with updating courthouses. But the history of that fee and the source of those funds would be helpful in answering Representative Gray's questions.
Mr. Chairman, I'm going to ask Lily to ask. She remembers the dates, but I can tell you this, and I understand folks' frustration, but it's a shared responsibility as for the more than 10 years or almost 12 years I chaired appropriations. I brought Judiciary in every year, asking them, inquiring about this issue. And we monitored it annually. And I'm assuming that the Appropriations Committee continues to do that, but I don't know. With respect to the progress, all of the work when you're doing these conversions, none of us abandon the work isn't. You do change vendors along the way because a vendor can't perform. But when the vendor can't perform, that doesn't mean all the activities, the work that you did, the case management development is abandoned. It means that you do have some times where you false start with a vendor and you go to a new vendor, but the work that you developed, getting everything scanned in, getting all the records throughout the state in a scannable form, getting them where they can be in PDF, that work is not abandoned. That doesn't, it just takes time. And you can put what I discovered as JAC, and let's take the state engineer as a great example. State engineer wanted to put all their records electronically. And we sat down and said, okay, how much fuel do we put in this? Because if we wanted to get every record back to your water rights back to the 1800s online, you had to go back and physically scan it. And then you just look at the total cost. And the question is, did we want to spend $20 million or $80 million or $100 million to get it all done quickly? and we chose something in between. When it came to the courts, once we got, with the first thing that we did is got the Supreme Court e-filed. Now they're e-filed and do all that work. The next thing we did is focus on the district courts in terms of priority. And when we sat there, the budget, we did create the court automation fee, and we gave them general appropriations to move forward. But the speed at which they go is in part the rate at which we appropriate funds to them. If you wanted to do this tomorrow more quickly and you wanted to quadruple their appropriations, they'd get there. But the reason I'm asking that I came here, and Madam Chairman, I asked that I would like to, from now to for the next year, we'll report to you, this committee, you're the home committee for the Judiciary, and we'd like to report to you regularly so that you see what's going on and you're part of the progress. Now, when it comes to the Appropriations Committee, they should be part of it too, and we'll report to them.
Well,
But
Mr. Nicholas, we have received updates. The Judiciary Committee has received updates regularly from the court on the topic. So we have been apprised. The Joint Appropriations Committee did take it up this last interim as their #1 priority to review and evaluate. So I think the legislature still has been spending a significant amount of resources and time trying to get their arms around this piece. We just appropriated additional funds this past year in order to make sure this project is a go, continues to be a go. So
I think Lily's the best person, Madam Chairman, to ask to talk about the change in vendor, which is what Representative Gray was really concerned about, and that is what resources did we lose in time, and I mean, there ought to be accountability. I think Lily could probably speak to that best.
Ms. Sharp?
Representative Gray, I appreciate, I appreciate your concerns, and believe me, we all had those exact same concerns. This actually occurred, the termination of the contract with the vendor, that actually began in about 2015 and 2016. And that wasn't that vendor though, and again, this is a little bit complicated, that was a case management vendor, and we actually rolled out the whole case management system throughout all the district courts. And Tina Wood is here, and she's really can tell you why the system didn't work, but it just didn't meet the needs of the district court clerks. The main thing that was wrong with that system is there was a faulty algorithm. And so when it migrated the financial data of all the district court clerks, much of that data was not accurate. And so the district court clerks just had a heck of a time, because they're the ones that are accountable for all the funding and the financials that attach to each of those cases. Just so you know that the circuit and district courts bring in each biennium and then send out to all the counties and to the state $58 million a year, or $1 million a biennium. So the district court clerks and the circuit court clerks, they also act as banks basically to give all the money to the counties for their school funds. And so it was critical to the district court clerks that we found a system that they could trust with the financials. So we did terminate, we worked with the Attorney General's office, and yes, JAC fully knew exactly what we were doing. And we terminated that contract, and we entered into a new contract with a new vendor that we had history with. We have, and I'm kudos to all of the circuit courts, we have almost fully rolled that out in the circuit courts, and we will start rolling it out to the district courts in January, in the beginning of next year. So it has been, the new system has been a huge success. And so, and all of us, I can say all of the staff who works here with me at our now in court administration, we are all new. We came here in about 2015, and we have made this a very major priority to get the case management system out. And now we're actually very excited because we are entering into a contract for e-filing. And once we have that solid case management system in the circuit courts and the district courts. As soon as those district court clerks, and Tina can talk about this, as soon as they have a comfort level with their case management system, then we will be able to pilot the e-filing system. But we need to do that in partnership with you. We have talked to the National Center for State Courts. We've also talked to Florida and Michigan, who have done the exact same thing before us. And the way they did this, what they've all said, and the National Center for State Courts has said, the most important thing before you go to e-filing is to make sure your statutes and your rules have been clarified, so that right now what happens is, and again, Tina can explain this, but Tina basically, Tina Wood, she interprets what she thinks is this document is confidential and available to this party, or no party, or an agency. And then the clerks, what they do is they color code their files, and some of them tape them shut, some of them put them in a back room, depending on their level of confidentiality. Well, the statutes all use words that are for the same thing. They'll use the statutes use the word secret, confidential, sealed, available. So when we go from using color-coded files and different clerks of courts interpretation of what the statutes mean, we have to have a uniformity. So all the clerks and all of your paralegals, for those of you who are lawyers, your paralegals, your legal assistants need to know how to mark this document when you file it into the e-filing system. So what we're trying to do is really best practices. And that is, we've been, the National Center has said, please work with your legislature, help clean up the statutes. They suggested, Florida has suggested, and Michigan suggested, that you create this matrix. It's my understanding that what Florida actually does is that matrix is actually adopted, reviewed each year or each biennium by the legislature, and it's adopted by the legislature. And so we're excited that we are at this point. Senator Nethercott, Chairman Nethercott. So while if you saw that the Gantt chart that Senator Nicholas put up, former President Nicholas put up, while you are doing this analysis and hopefully reviewing this bill draft that we would like you to sponsor, we behind the scenes will be configuring the case management system. So we don't have to have this matrix out and done, and then the statutes completed the day we start e-filing or piloting the e-filing system. But it is highly recommended that we get it done. And that what they've said is that then it makes it so much easier for clerks and for the attorneys who are filing into the system to know how those documents are accessed. And that's all, Chairman.
That's it, huh? All right. Well, thank you, Ms. Sharp. Representative Gray, follow up. Hand is still raised. Nope. Representative Salazar.
Thank you, Madam Chair. So, Ms. Sharp, maybe you can help me going forward. Can you talk to me about the fiscal note of the bill that you might be looking for? Is there a fiscal note? Is there a cost to this? What will be the cost of keeping the system up in the years to come? Can you help me with the numbers on that?
So Representative Chairman Nethercott and Representative Salazar, the main cost for this bill will be, we would like to have Brian Fuller do nothing but work with us for the next year. So there will not be a cost on this bill draft. The cost of the system, you have already appropriated to us, and including the first, I think what we're trying to negotiate, actually, we'll see if we can get it with a vendor. We are trying to negotiate with them that they will not increase the cost, the maintenance and support cost, for at least 5 years. We don't know if we'll get it, but we're working as hard as we can to get the best value we can for the buck. But you appropriated, I believe it was $2 million for the system. And what the system is, it's actually a system as a service. So the e-filing vendor will do much of the work, They will actually provide the training for the lawyers, training for the district court clerks. Our staff will help, but they do a lot of it. And just so you know, this vendor, the vendor that we hired is the vendor who started e-filing in Colorado. Actually, what happened is LexisNexis started the e-filing in Colorado, and then this vendor purchased LexisNexis. So it's the same, so they built off that same system. They were also one of the very first e-filing vendors, or were the first e-filing vendor in Texas. And at some point, we'd be happy to bring the vendor to speak with you also. We actually first want to get our contract written so we have a lot of, so we can negotiate a good price on it.
Madam Chair, follow up.
Yes, Representative Salazar.
Thank you, Madam Chair. So I want you to succeed. I want you to succeed. I just want, it's helpful to have a heads up on the cost. So I appreciate your answer that you don't see any fiscal note to this bill, that you're taking care of for a while, and I appreciate that answer. Thank you.
Madam Chairman,
Mr. Nicholas.
if I may, from an appropriations point of view, the bill that we're speaking of now is simply a sort of a codification of the electronic filing system in the statute. So other than the cost of drafting, you would not expect to see any appropriation attached to the bill. The appropriations for the court's automation system is actually embedded in their current budget, so there's already an allocation for that. But one of the things I want to just remind folks is that when I was on appropriations, I was completely stunned by how much it cost the state of Wyoming to maintain paper records. If you think about it, first of all, the counties have to build buildings, they have to build filing spaces, they have to have places for brick and mortar to actually store paper, and there's a massive amount of paper. When you get done with that paper then eventually finds its way to Cheyenne at archives at A&I. Archives then retains those paper records forever. Not only that, but they take the electronic, those papers, and they convert it to electronic PDF and to microfiche. Your budget every year to maintain and keep these court records, permanent records, is massive. I mean, I'll just pull out a number. My recollection is you're probably spending $15–20 million a year just to retain paper records. So that's going to be a redundant cost because we're going to do both. But in time, you're going to shift a cost that was creating paper, maintaining paper, to creating electronic records and maintaining electronic records. And that's true statewide. But if you look at the cost, for example, of having the idea is a highway patrolman eventually can put a citation in a computer, and that citation will populate all the way through the court system and to everybody that needs to have it. Without that, he has to do a paper citation. He has to deliver it to the court system. They receive a piece of paper, and you can imagine all this paper traffic that occurs. So in time, the electronic system will ultimately save money. And we have another side of our government, and that is we want public records to have people to have access to public records. But just remember, the cost of maintaining and keeping paper is very, very expensive, far more than you probably appreciate. Thank you.
Thank you, Mr. Nicholas. With that, we're going to move to the other members that are with you that you have identified to see if they have any additional comments they'd like to add. We have been on the topic for an hour. We have a different section to get to under Wyoming Supreme Court updates and bill drafts. So whereas we have time, just want to be mindful of that time. Justice Gray, Ms. Butler, Ms. Wood, if you'd like to take a moment, whoever would like to go first, just go ahead and unmute yourself.
Chairman Nethercott, Chairman Kirkbride, and members of the committee, we just want to say thanks for letting us come and give this report to you. And we're really pleased that we have Senator Anselmi Dalton and Senator Ellis on the committee, and we do intend to come regularly. I don't think I have a lot to add. It was thoroughly discussed, and I think you know what we're doing and where we're at. And we intend to come back, and we're available for questions. and to talk about this further with any one of you. So I just want to thank you for your time today.
Clerk Wood or Elisa, any comments?
Madam Chairman Nethercott, Tina Wood, and Co-Chair Kirkbride. Good morning. I just want to, I'm going to be short and sweet. I just want to say that I appreciate the concerns that the legislature has voiced, and that this committee has been assigned, and I appreciate being appointed to that. As you all know, I've been around for a long time. I was on the original design committee for our current case management system. It was, in Lily's presentation, she said, there was some financial issues. There was initial financial issues because it was the vendor's first accounting attempt. And so we struggled through those, but pretty much we're pretty, stable on those. But we did have frustrations with that vendor. They were not addressing the bugs to the issue, to the program and things like that. And so it gave the clerks a loss of confidence in those, that vendor, and the Supreme Court took that and moved forward. And so we appreciate the fact that everyone is concerned about the protected views of what each of the documents that we do get filed. We will say we have noted that, yes, it is the attorney's responsibility to make sure that there is that confidential information redacted. But unfortunately, as we are the ones who are on the front line and boots on the ground, we see that unfortunately not being followed. And so we just want to make sure that we are protected, that it is not going to come back to us as getting that information out once it becomes public. I just look forward with working with all of the committee members and appreciate every member that is on there. We have a great bunch of people around the state that will assist us in making sure that this moves forward. Thank you.
All right, thank you, Clerk Wood. Ms. Butler, anything from you before we close it out?
Madam Chair, Mr. Co-Chair, members of the committee, I just want to say thank you for allowing us to speak to you today, and we look forward to working with you in the future.
Wonderful. Okay, Mary Beth, do we have any public comment on this particular topic that you're aware of? I know we have a couple of individuals in the waiting room that may want to speak out. A couple of judges. I think they might be on for our next section, but.
Madam Chairwoman, I don't believe so, but Judge Rumpke, I believe, is available if the committee has additional questions. I don't believe Judge Fenn has signed on quite yet, but I do believe he wanted to wait until after the Wyoming Court Supreme, this topic is over.
Wonderful. I think you're right in that they're all waiting anxiously on the next section of our morning. So with that, we'll shift to that. Thank you all for your work and the wonderful update. We look forward to making some decisions about that later, and I'm quite confident that we can handle some of the technical changes to the statutes that need to occur. So sounds doable. We'll get her done.
Thank you very much, Madam Chairman and Co-Chairman Kirkbride.
Thank you, Mr. Nicholas. All right, with that, we're going to go to the introduction of bill drafts with LSO. So whoever might be doing that, Mr. Fuller.
Chairman Nethercott, do you have a particular order that you would like to cover these? The only thing I would note is that 47 and 83 would go together for those bill drafts. The order I have is 82 first, and then 47 and 83, and then 48 is what I have as the fourth bill draft. And if the committee's fine with that, we can proceed in that order unless there's a different order the committee wishes to go in.
Mr. Fuller, thanks for asking. I think in light of the district court judge's time and their interest in the issue, we will start with 47 and 48 and 83, kind of 47, 48, 83 in that order.
Okay, well, I'll begin then with 21 LSO 47, should be working draft point 3, district court budget submittal repeal. Chairman Othercott, members of the committee, page 1, line 7, this bill draft simply repeals 53113. Just by way of brief background, the committee received a research paper from Ms. Creech regarding the structure of courts in other states and administrative oversight of courts. And after hearing that report, the committee asked for a bill draft to repeal language regarding how the district courts separately submit budgets, and then a separate bill draft to repeal language that provides that the district courts are free of administrative and fiscal control of the Supreme Court. So with that in mind, back to 47, the bill draft itself is straightforward. The staff comment on page 2 just first lists out that language that is being repealed in 53113. And then there are a couple of considerations for the committee to perhaps note or address in reviewing this bill draft and the other one. And I'll let Mr. Hopkinson discuss some of the specifics with 53102. But just generally, we would note that what is stated in Article 5, Section 1 of the Constitution is that the judicial power is vested, quote, in a Supreme Court, district courts, and such subordinate courts, end quote, that the legislature may establish. Article 5, Section 2 provides that, quote, the Supreme Court, omission, and then shall have a general superintendent control over all inferior courts. There is no case law in Wyoming that describes what is the nature of the district courts, given its specific and explicit mention in Article 5, Section 1, and what exactly is meant by the general superintendent control, and how that, at least for this bill draft, would extend to the budget for the district courts. Some practical considerations for the committee in light of this bill draft that would repeal these requirements. The committee may wish to consider whether in this section or a new section, the question of who submits budget for or on behalf of the district court, if that should be spelled out in statute, whether there should be a deadline for the submission of standard and supplemental budgets for the district courts. Currently, that's November 1st. And whether there should be specified methods or practice requirements for what those budgets look like when they are submitted to the legislature. The language in 53113 requires the district court budgets to be submitted in the same manner as the executive branch would submit budgets. I think the question would be, by just simply repealing this language, what can the district courts do and what do they have to follow in submitting their budgets? For example, for a budget session, could they show up with their budget on January 15th in the absence of any section specifying otherwise? So with that in mind, that's the bill draft. That's 47, and I'm happy to answer questions for the committee.
Questions for the committee on this bill draft, and then we'll have Mr. Fuller explain the next bill draft, because I do think they are connected. And so we'll have him explain the bills, and then we'll hear public comment on kind of both bills at the same time to be efficient with resources here. So any direct questions on this bill draft for Mr. Fuller? Seeing none, Mr. Fuller, do you want to go to the next, or Senator Von Flatern?
Thank you, Madam Chair. So who does submit the budgets? And if we're repealing the budget here that they submit themselves, who does submit it?
Chairman Othercott, Senator Von Flatern, right now I believe each budget is prepared and is submitted. In the absence of this section, I think that is an unanswered question. I suppose, one of two things could in theory happen. First would be the district courts submit their budgets. The second would be the Supreme Court would collect, prepare. I'm not sure how that process would look, in terms of how those budgets would be submitted going forward in the absence of this section.
Any follow-up, Senator? Go ahead.
So what was the history? Why did we want this bill to come forward? I'm sorry, I missed that part.
Representative Stith, if I could turn to him real fast, I think he was the one who made the motion, and then we'll have Mr. Fuller follow up, and then we'll get to Senator Anselmi Dalton.
Madam Chairwoman, thank you very much. It's my understanding, and the other witnesses who are more on the ground can testify whether it's exactly accurate. It's my understanding that right now the district courts are not submitting their budgets directly to the Joint Appropriations Committee. Right now, the Supreme Court's actually doing the work for them as a practical matter. This Bill 47 goes with the, I believe it's number 83. The idea is about 18 years or so ago, the statute was adopted that said that the district courts shall be free of the fiscal and administrative control of the Supreme Court. It's, for a lot of reasons, I just think that's a really bad idea, and we need a different system. But part and parcel of that is if you restore the Supreme Court's managerial control over the district courts, if you do that, then it doesn't make sense for the district courts to be doing their own budgets. So that's how they connect, in my view.
Mr. Fuller, anything further to add as far as information on answering that question?
Chairman Ellicott, Representative Stith was the one who brought the motion. I think he's captured the intent behind it.
Okay, looks like Senator Anselmi Dalton, did you have your hand up? Did you have, no? Okay. Senator Von Flater, did you have follow-up to your question? Then I'll get to Representative Parnell. No, okay, take your hands down if you're not still asking a question with that Representative Parnell.
Thank you, Madam Chair. So I guess my question would be, is there a need for this bill if the district court remains the same as it is now? I mean, is there a need to continue down this path? Because I kind of have questions on them going under the direct supervision of the Supreme Court. So that, do we need this bill? If that doesn't happen, do we just need to leave things alone?
Great question. I hope we can discuss that in our discussion. So direct any further questions to Mr. Fuller on the bill. All right, with that, we'll go on to the other bill number, and I don't want to say the wrong bill number, that is part and parcel with this particular piece of legislation.
Yep, and that would be 21 LSO 83, and Mr. Hopkinson will go over this briefly.
Thank you, Madam Chairman. 21 LSO 83, I'm looking at working draft 0.4, District Court Administrative and Fiscal Control repeal. This bill draft simply repeals Wyoming Statute 53102B. That statute is the one that kind of has been touched on already in a little bit in the discussion. It provides that the district courts shall be free of administrative and fiscal control by the Supreme Court. And for that, in the staff comment, there is a copy of the repealed section there. That also provides for the judicial conference for the district court judges, where they adopt rules for judges, adopt rules for the administration of the district courts, for just about everything except for technology, and rules for the division of work between the judges, as well as keeping minutes and providing those to be made public. So in its consideration of this, should this bill draft go through, the committee may also wish to consider whether it wants to repeal the judicial conference in its entirety, or simply kind of take a more surgical strike at this statute while keeping the conference intact. The committee may wish to consider who adopts rules governing the administration of the district courts and whether the legislature or the judicial branch should decide that. Whether there needs to be a requirement for an integrated statewide system in terms of personnel, budget, and fiscal policy. Whether there needs to be any provision for the adoption of rules for dividing work between the judges. If it's simply repealed, it stands that each district court could adopt those rules, or the Supreme Court. And then the same constitutional matters that Mr. Fuller has already raised to apply in this section as well. The bill draft will be effective July 1st, 2021, and I would stand for any questions on this draft.
Thank you, Mr. Hopkinson. Any questions for LSO? Looks like Representative Washut has one.
Thank you, Madam Chair. I'm assuming there was a reason why 53102 was adopted back in the day. Is there any history as to what was going on and why this move was made back when 53102 was adopted?
Mr. Hopkinson, if you know, or Mr. Fuller, or anyone?
Madam Chairman, I defer to Mr. Fuller if he knows.
Chairman Nethercott, Representative Washut, I was unable to discover any real background to this. I do know that the language in 53102B that provided this language about the district courts being free of that control came in 2000, in a House bill in 2000. Beyond that, at this point, I don't have much more to add.
Thank you, Mr. Fuller. I do think that's interesting for how it came to be and in relative recency too. Maybe just I see Ms. Sharp is unmuted. Maybe, no, she's not. Ms. Sharp, do you happen to know the answer to that question? She's probably not.
I'm sorry, Chairman Nethercott. So there's a long history, and I would actually defer, if you don't mind, to Judge Fenn, because although I know the history, they know it, the district court judges know it far better than I do. So if you don't mind, I'll turn it over to Judge Fenn.
Judge Fenn, please introduce yourself to the committee. Good morning. Great to see you. Go ahead and enlighten us on the history of this particular piece of legislation that's been on the books for
Chair Nethercott and distinguished members of this committee. Thank you. I am Judge John Fenn. I am the 4th Judicial District Judge that covers Sheridan and Johnson County. The specific history, I wasn't a judge at the time this was enacted, but the core of this is judicial independence, even within the judiciary. And the importance of having the district courts independent of other courts is just fundamental to our principles. And so that's the motivating force when it came to be. As you might recall, there was many of these things lead to personalities that were involved in, and I believe there were some pretty strong personalities on the Supreme Court and on the district court bench that ultimately resulted in this coming to be. The Supreme Court, from the view of those personalities on the district bench, was overreaching. And so they said, this is wrong. You're interfering with our ability to be independent and make the right decisions and protect the rights of our citizens. You have appellate overview, you have a lot of different overview, but you don't have fiscal overview and administrative overview. And I believe that's why it happened. And particularly with the individuals that were involved at that time. We had a particularly strong Chief Justice and particularly equally strong district court judges. So that's what I believe why this was enacted back in 2000. Chair Nethercott, I have a longer presentation. I was going to wait until the end as public comment, but if you would like me to do it now, I'd be happy to. I'm at your pleasure.
Judge Finn, thank you for recognizing the two pieces of that. And thank you for answering that question. Certainly not surprising to know that some lawyers or judges have some strong personality. So appreciate hearing that candid answer, and that's how it came to be. Any questions of Judge Finn about maybe that process for how it came to be or his knowledge associated with that? All right, with that, any additional questions for Mr. Hopkinson or Mr. Fuller about the bills? Seeing none, then we will go to public comment on it. So Judge Finn, if you'd like to start, since you're readily available, we'll go ahead and have you just transition into your presentation if you'd like.
Thank you, Chair Nethercott and Chair Kirkbride and members of this committee. I think that a historical background of our form of government is helpful to understand the importance of these issues that are raised by this. If you look back in history, we have moments of genius. When Thomas Edison invented the light bulb and Isaac Newton discovered and defined gravity. And in political science, our forefathers were truly political geniuses in what they created in our form of government. And they were faced with a challenge in that they wanted a democratic government ran by the people, controlled by the people, but they also wanted to preserve individual rights, those fundamental individual rights that would trump majority rule, such as freedom of speech, freedom of religion, right to bear arms, due process, jury by trial. And so they came up with a system that this three-branch system that we have, an executive branch and a legislative branch and a judicial branch. And the compromise that they made and the genius in which they made it was the executive branch and the legislative branch represents that majority rule component of our government. And as the political winds change, so does the makeup of those two branches of government, and they reflect what the majority rule is. But in order to preserve the individual rights, those precious individual rights that they recognized, they set up the judiciary as an independent branch. And the judiciary is not a majority rule branch. It is a static branch. Its loyalties are beholden to the Constitution and those individual rights that we have to uphold. And the citizens look to the judiciary to preserve those individual rights, and the judiciary has to be independent of majority rule, because as political times change and majority rule changes, you can't willy-nilly take away and put back individual rights. And if you look at other forms of government, such as Russia or China or North Korea, they also have, quite frankly, similar forms of government. They have an executive branch, they have a legislative branch, and they have a judicial branch. What they don't have is an independent judiciary that has the ability to preserve and protect those individual rights that we as Americans cherish so much. And that is an important distinction, and it lays the ground rules and the lenses in which you must look at these legislative efforts. And viewing those these particular bills through that legislative lens of judicial independence, I think it just shows how haphazard and dangerous it is to enact these bills and repeal the independence of the judiciary, and particularly within the judiciary between the district courts and the Supreme Court. It's often a slippery slope argument, and with respect to some of these bills that you'll be talking about in the near future with respect to e-filing and the workload study and the ethics, those are kind of slippery slope arguments that I think we always need to be on guard on the judicial independence. But frankly, the courts are doing much of what is set forth in those bills by rule or by practice voluntarily. And those bills I don't think are necessary, but they are sort of on the upper slope of the continuum of a slippery slope that we must guard with respect to judicial independence. These two bills, 82 and 83, are jumping off the cliff. They are completely changing the structure in which our judicial independence is based, and it's a real problematic. I understand that the Supreme Court, and I'll let Chief Justice Davis talk about this. The Supreme Court isn't pushing this. They don't necessarily want it. The District Court Conference absolutely doesn't want it, and so we're puzzled as to what the motivation is. It certainly won't save money, and the notion that we will be better by it being overseen and supervised by administrative bureaucrat in Cheyenne, all due respect to those folks in Cheyenne that I work with closely on a daily basis and like and admire, that is not the direction you should be going, giving up local control. And the pandemic has really seen, we've seen that recently in the pandemic. Each of us are dealing with our own unique issues and challenges to conduct our business with the support of the staff of the Supreme Court in a coordinated effort, but we are making those local decisions. And to turn that over to a Cheyenne control is, I think, just a tremendous mistake. And I ask you, if somebody in power is limiting your political free speech, do you want to bring that matter before a judge that has worried about finances and impact that somebody in Cheyenne is telling them they have? Or do you want somebody that is independent, accountable to its local community, and making decisions that are appropriate without interference, even within the judiciary? And it's worth noting also that this notion of judicial independence doesn't mean that judges are just free to do whatever they want and we're just running amok. There are many restrictions on our abilities. First, it starts with our merit-based nomination system. Our merit-based nomination system is purposely intended to be non-political, to eliminate the politics, and we are a non-political appointee. Second, we have the appeal process. Everything that the district court does can be appealed for the most part to the Wyoming Supreme Court, and the Supreme Court certainly has appropriate oversight with respect to the appeal process. We're also governed by very strict rules of judicial canons. And I've had a chance to briefly look over the ethics bill that you talked about yesterday, and I kind of smile because the judicial canons are much stricter than what is in those that ethics bill. And I don't think there's really any problem with a court complying with that ethics bill, but it's unnecessary. And it's an interference, a slippery slope interference on our judicial independence. We further have oversight and enforcement of those canons by our Board of Judicial Conduct, which is an active board, a constitutionally, I believe, created board during the reorganization back in the 70s. And the court's answer to that as well. Finally, and probably most importantly, is we have a retention process in which our local constituents vote yes or no on our local judges. And to interfere administratively and fiscally on what a judge can do in his local area and his budget makes us beholden to the wrong people. We are not beholden to Cheyenne administration. We are beholden to our local citizens and constituency.
Judge Finn, your chairman right now is from Cheyenne.
I'm well aware of that. And that's part of the reason that I've been asked to be here today, is to show that we have more than we have. He represents a broad spectrum, all 23 counties. And even within our district courts, we're independent within our district courts. We work well together. We have a district court conference, but we are independent among ourselves. And there's a very important reason for that, as I've explained.
We have some questions from the committee members. Senator Anselmi Dalton.
Chair, I'm not,
Looks like you're on mute, Senator.
Thank you, Madam Chair. I appreciate that. Sorry, I didn't click it well. Thank you, Judge. The reason why I just have a few questions, it seems to me why should the circuit courts be under the Supreme Court but not the district courts? And particularly given that the Constitution says that the Article 5, Section 1 of the Wyoming Constitution, you know, and Article 5, Section 2 says that the Supreme Court shall have a general superintending control over all inferior courts. So that's why I guess I thought, you know, why should we have a split where the circuit courts report to the Supreme Court, but the districts don't?
Chair Nethercott, Senator Dalton, really there's two reasons. One is the district courts are also a constitutional court. They are different and distinct than the circuit courts by our Constitution. And secondly, I will tell you, in my opinion, the circuit courts should be independent as well. And if you talk to some of the circuit court judges and the way they manpower things, I think it's an inferior method. And I would be arguing that the circuit courts should be more like the district courts.
Oh my God.
I don't think the circuit courts are as independent as the district courts, and that is not a plus. That is a minus.
Follow up, Senator?
Madam Chair, but Judge, thank you, Madam Chair, but Judge Finn, it still doesn't, I'm still looking at the Constitution. I mean, I'm feeling like maybe we need to amend the Constitution. I think that what we enacted in 2000, while you like it, and maybe that the other courts like it too, it still conflicts with what I see in the Constitution. That's where I have some concerns. So can you answer what I have to do about Article 5, Section 2 and Article 5, Section 1 for me, Judge Finn, please?
Judge?
Chair, you know, the Constitution gives supervising ability by the appellate courts through the appellate process, but I don't think they need and should have fiscal and administrative oversight. In fact, it interferes with that appellate process. It's not inconsistent to have the system we have now and the independence that we have between the district courts and the Supreme Court, particularly because if you look at the Constitution as a whole, the district courts are separately created courts. They're the court of general jurisdiction, and to have to answer to the Supreme Court on whether or not we can buy this or do that is a real impact on the potential independence. And it depends. Again, the big fear is not maybe with the current Supreme Court administration, but people change and personalities change. And I've heard of horror stories of in the past where circuit court judges had to account for how many rolls of toilet paper they were using because of mandates coming down from a particularly zealous Chief Justice. I just shake my head and laugh. I don't want that to happen to the district courts. It's a mistake. I hope that answers your question, ma'am.
Judge, any final comments before we shift over to, I think, Judge Campbell, who's also here on the agenda? I think he's ahead of the judicial conference as well.
Thank you very much. I'll be happy to answer any further questions, and I appreciate your time. And I recognize I'm very zealous and passionate about this. I'm very concerned that this effort is going underway, and I take very much pride in the work that we do as district court judges. We work very hard, we're committed, and to limit in any small way, or in this case, I think large way, is detrimental to ultimately the citizens of our state. So with that, thank you, Chair and members of this committee.
Judge Finn, stay close if your time allows in the event that there's additional questions for you as we hear additional testimony. So if your time allows, please stay on, and if it doesn't, we understand.
I will be here through the morning.
Wonderful. Judge Campbell, are you out there? Judge Campbell is one of those Cheyenne judges. Welcome, Judge Campbell. You're familiar with the committee, but if you would please reintroduce yourself, and we're happy to hear from you on this topic.
Wonderful. Judge Campbell, are you out there?
I am. I have followed instructions and should be video and audio both, if you'd confirm that for me.
We can see you, but you're going to want to turn off your live streaming on YouTube.
Welcome, Judge Campbell. You're familiar with the committee, but if you would please reintroduce yourself, and we're happy to hear from you on this topic.
Very well, thank you. Thomas Campbell, I'm a district court. I am. I have followed instructions and should be video and audio both, if you confirm that for me. All right.
We can see you, but you're going to want to turn off your live streaming.
There you go, took care of that, thank you. I'm Thomas Campbell, district court judge now in the First Judicial District here in Cheyenne, and the conference chairman this year of the District Court Judges Conference. Been a judge since this law was passed. Actually, was in 2001. I was appointed. As to, if I could begin, if you would allow me, just one additional take on the history, motivation. Judge Fenn spoke to the perhaps personalities and some struggle, and I'm aware of this struggle. It was a friend of then Justice Lehman, who chaired, as many of you remember, Judicial Planning Commission effort. Lasted a couple of years and resulted in significant changes. It created the circuit courts from the county courts. It changed some jurisdictional things in the assignment law. And during that time, a lot of things came up, including personnel policies. And so the history of it is not just personalities. And I would not want to minimize it to be, well, some of the older judges didn't like this or that some Supreme Court justice did. To be sure, that was in the mix, I'm sure. But significant and change was underway. The legislature had acted on this planning commission activity. And that's another part of how we got that statute. A small part, but certainly a part as well. I'm a Cheyenne judge, and I know that Senator Chairman Nethercott did not need to make light of the fact that I'm a Cheyenne judge, because John or Judge Fenn had said all those dang Cheyenne judges, or Cheyenne. I want to make, all kidding aside, I want to make something clear. Judge Fenn's experience and the passion that he exhibited today is no different. He's just more eloquent than me, and I'm going to try to repeat a lot of what he said, but he speaks for this conference. There is uniformity in the conference that the beliefs that he espouses and their practical effect on whether or not we should be repealing and so forth, he speaks for all of us, and as I say, I'll try not to repeat. I also am generally aware of what the chief will address, and he has many things to say, and I anticipated following him. So I want to refer you to the chief on as to some of these things. But other than the history, the changes and repeals, I don't mean to make light of the constitutional or legal struggle. I think Senator Anselmi Dalton mentioned that, well, it says this in the Constitution. Well, ultimately what happens is some court, and we're the courts, are going to have to decide, I suppose, would ultimately have to decide if you mention the district courts in one fashion, in one part of the Constitution, what does that mean as to the superintending language in another part? And that legal struggle is not one we should comment on. I mean, we say the struggle, Mr. Fuller identified, boy, there's a struggle there, but we can't opine about that. We can only say, boy, that might be a problem down the road. Or a problem to consider. Having gotten past that, though, the bills and the changes themselves it did baffle us. We've met a number of times since the first working group or the first committee meeting here, and have tried to maybe glean from what some of you said in open committees or in other conversations, what maybe is wrong that generated this. And I got a hint from Representative Stith today about his about his analysis and struggle and how these bills maybe work together. I had not heard of the Creech report that you mentioned. I had not heard of an analysis, but would say, and in a follow-up to Judge Fenn, we're not anybody else. We are who we are in Wyoming, and constitutionally and otherwise, but I could not otherwise comment on what even a very authoritative review of court systems might say. I know, though, it's been 37 years as a lawyer. I've lived through various iterations of this, and I've lived through what you all are discussing now, the bills that are for which repeal is suggested. I don't want to oversimplify this, like if it's not broken, don't fix it. But I want to emphasize that in addition to the local control sort of aspects that have been mentioned, this works. This administrative statute, no matter its generation, has worked. It has created a conference that has its own rules. Even some of our rules deal with that case assignment. We have a rule that creates a committee that can help judges with docket control when there's been extreme circumstances. I myself have benefited from the assistance created by that rule. So we don't just email each other and say, hey, what's up? We have 3 meetings a year. We conference now even more, of course. We conference even more. And those rules, they're only 5 or 6 pages, combined with our work with the with the Board of Judicial Policy for the overarching policy decisions, have made us in the Circuit Court and the Supreme Court sort of a coexisting supervisory or at least policy-making authority and a check on authority. The rules that everybody operates under that go through the Supreme Court come through committees to ultimately to the Supreme Court, but through that policy committee. So there's a true opportunity in the board for there to be discussion of what works for the Circuit Court, not for the district, and so forth. The accountability I won't touch on. Judge Fenn has certainly mentioned that. We are concerned that if there is a problem, and I've heard a hint of it, I'm not sure what it is, and we all struggle with that. And I want to step back from that and emphasize to you all that if there's a problem and there is an issue, we're not just saying don't do anything, but through the committee process, and this is the second meeting in the committee process, we haven't yet learned about a specific, I think that I can address, but we're willing, and we'll come back to you. We'll write to you in between. We'll do anything to identify a fix if that's the case.
Judge Campbell,
I'm sorry, Chairman.
If I may just kind of address this issue with a little bit more.
I can't hear you.
Yeah, unmute your audio on your computer.
You are breaking up on my chat. Stand by just a minute.
Okay. So to provide some history to, I think, the district court judges and maybe the conversation statewide, and maybe a fundamental issue that I'm hearing is that there's an assumption that there's a problem or some type of.
Chairman Nethercott, just one moment. I apologize, but just one moment.
It's court automation fees.
I beg your pardon, I'm behind. If you would repeat your question, please, Chairman, I'm sorry.
No, sure. Thank you, Judge. I understand. To maybe provide some information right now as you prepare your comments, and we'll come back to the confusion of the district court judges for how this issue came to be.
Just one moment, I apologize.
Probably is not as exciting as the judges think. And what I have taken note of is kind of the inclination to believe that there's some type of allegation of a problem or a criticism of the judges, which is not the case. So the issue came out of an origin, I think, of stages where there's a desire to add additional district court judges in the state. And so as part of that process and reviewing that question, or how many, what should that look like, where should they go? There was a request of LSO to understand how other states make those determinations, not only in workload, caseload studies, which you see later on our agenda, but also on how the courts operate and if an efficiency can be created in balancing district court judges' workloads. Not that there's any problem or issue necessarily. So in May 2020 at our judiciary meeting, a report was provided by LSO staff, which is Danielle Creech, and you can find that material online, and you can also watch the meeting online to see how that conversation transpired and hear how Representative Stith presented his motion and the discussion that followed on the topic. And I think that would probably do everyone's heart a bit of good in recognizing that it wasn't any particular response, any particular district court judge's action or inaction, but rather as part of a larger conversation about whether there's a smarter system for judicial efficiencies. And this is just kind of part of that work. So I don't think anyone or any legislator has a particular agenda on district court judges or the Supreme Court, but really kind of naturally, organically transpired as a result of that report.
Thank you.
Whether there's a smarter system for judicial efficiency. And this is just kind of part of that work. So I don't think anyone or any legislator has a particular agenda on district court judges or but really kind of naturally, organically transpired as a result of that report.
Thank you. And if I'm working now, and I'm doing my best, it is my malfunction, not yours. Several have informed me of what I need to do. And I was at that meeting, and generally understood, Chairman, and I hope I wasn't being offensive to anyone, but the mechanical change and the void, and I think your staff has pointed out since, the void created would be a void filled perhaps by a Supreme Court that would need additional people, additional administration, and would eliminate the local control and local decision-making, or at least complicate it, that Judge Fenn mentioned. What I'd like to do, other than that, if I could, is before I go to questions, is just remark that much of what I've discussed and what Judge Fenn has discussed can also be addressed, of course, by the chief. But as to the district court position, that it does not need modified and would be a serious issue in the ongoing administration of our local district courts if it was repealed. I think I want to leave it there and go to questions if anyone has any, and then you could move to the chief.
Questions for the judge? The Cheyenne judge? All right, let's go to Justice Davis if we can. Chief Justice Davis.
Thank you, Madam Chairman, Mr. Co-Chairman, members of the committee. Thank you for the opportunity to speak to you today. I guess I'm twice cursed because I'm in Cheyenne and I used to be a Cheyenne district judge. In fact, Judge Campbell is sitting in my office, what used to be my office right now. But I do have some comments, and Madam Chairman, if I may, I would just hit both the repeal of the statute 53102 and the budget revisions. Both it would be both 83 and 47, and I'll do it quickly. First of all, with regard to the repeal of that statute, these seem to be policy issues related to the organization of the judiciary, and those fall within the powers of the legislature, subject to any constitutional limitations. I think I and the rest of the court are kind of unsure of the problems this bill is intended to address. And if there's something through further discussion that we could respond to, that would be great. But I just wanted to say this. We are going through possibly the worst time our judiciary has gone through in recent memory. I don't know what the Spanish flu was like 100 years ago, but dealing with the pandemic has been extremely trying. And throughout that trying time, all levels of the court system have worked together to deal with what seemed to be insurmountable obstacles to the delivery of justice to our citizens and your constituents. And we've, as a group, overcome those and by working together. And that's been a two-step process. I think it was actually Judge Fenn that asked our court to develop guidelines for managing events as we went through the pandemic. And we worked with the chairs of the district and circuit court conference, recognizing that they're the folks on the ground. They know what's available in their courthouse. They know their infection rates in their counties. They know what resources are available to them. And we've recognized that. And they've responded by working with us on the guidelines and adhering to those guidelines. We meet weekly now. That was something we didn't do before with the chairs of the district and circuit conference. And we talk about COVID-19 issues and other areas of interest. So we've had a good general improvement in communications. I would guess we have the best communications. I'd defer to the Judge Campbell and Judge Christensen on that, but we probably have the best in ever that I know of. Now, I know in the past there was tension between the district courts and the circuit courts. In fact, I think it was outright animosity. There's a story about a meeting that involved the district judges in the Supreme Court. I can't tell you because it was profanity laced, and according to the reports I heard, and we haven't had any of that for a very long time that I know. I also want to say, if you compare the operations of our court system in these difficult pandemic times, I think you will find that we have, as a branch, been ahead of the other states most of the way due to that cooperation, willingness to let local judges who know conditions in their courts do their jobs, and by the common goals we have, as well as a technology that has been developed not by the Supreme Court alone, but with the assistance of the district judges and the circuit judges. I mean, I just continue to hear from, a couple of weeks ago, I was attending the National Conference of Chief Justices virtual meeting, and the folks in Delaware are still trying to figure out how to get the equipment they need to conduct remote hearings, which we've been doing since we knew enough to know that that we were going to have to do that, because we already had the equipment. Maybe some of the judges, like Judge Campbell, had a little trouble learning how to operate it, but it was just a little training issue, and we were able to get everybody up online, and they did their jobs. If I could touch on the budget statute also while I'm talking briefly, this is once again a matter of court system organization. That's within the purview of the legislature, subject only again to limitations of the Constitution. I just want to tell you how it works now. Our chief fiscal officer and her employees track the district court funds, and I think we actually even pay their bills as they come in. Those go through us and then the state auditor, I believe. The chief financial officer has the software to put together the district court budgets, and so they tend to stay pretty close to the same year to year. And so she provides them with a draft, and then they suggest revisions and so forth. So far, this hasn't been a problem for us. The district courts, as a result of what we do, has a CPA. Our chief financial officer is a certified public accountant, and staff to track their financials because the CFO does it. And then the district courts have their own system whereby they actually review their budgets. I think in the past, it was former legislators who are now judges who went over all the budgets and looked at things to make sure, I guess, nobody was out of line. And then the chairman of the district judge conference presents those to the Joint Appropriations Committee, occasionally with another district judge appearing if that judge has something unusual to discuss. I think this last time, Natrona County judges appeared to talk about the need for funding for commissioners, I think it was, to conduct Title 25 private or civil commitment hearings. So anyway, I guess once again, we're getting by pretty well. I think the budgets are accurate. It hasn't been a lot of work for us. And so we're all getting along. I don't know if Judge Campbell or someone else has something to say about the budget process, but that's what I have to observe on those two bills. Thank you, Madam Chairman.
Thank you, Chief Justice. Any questions for the Chief Justice? Representative Gray.
Thank you, Madam Chairman. So, Chief Justice Davis, my interest in this topic, I think different people have taken different angles, but my interest in this, and kind of is responding to the district court judges a little bit too, is I think independence is important, and I can understand that from a constitutional perspective and good government perspective, I think that argument is real. I do think there are some administrative functions in the judiciary that probably could be centralized without carefully done without damaging independence. And, I go back to the efficiency report where we went throughout the executive branch and said, here's the things, if we wanted to become more efficient in the executive branch, yes, every agency wants to have their own personnel department, but is that efficient and is that reasonable when we have this deficit and we face a real choice in Wyoming, a real Robert Frost moment? And I think we have to ask the same question for the judiciary. Are there some things that maybe we could centralize, some administrative functions, and that really wouldn't undermine independence, and we could do that carefully? And has that conversation happened, or is it just that it's become so separate through practice that it's just not possible?
Yeah, Chief Justice, I think Representative Gray's comments are fair and also lend itself to the motivation behind this. It isn't as a result of any concerns over incompetency or personality conflicts or any of those kind of concerns. It really is there a smarter way to do it?
Madam Chairman, Representative Gray, I think the misconception here may be that we are actually doing what the statute says in terms of the complete independence of the district judges. We handle all of their payroll. We have our personnel folks here at the court assist with any personnel problems that the judges may have. So that's where the personnel system is. We provide the budgetary assistance. We provide a number of other things. We contract for Westlaw, the research services, make arrangements for their equipment. We provide technology for the district courts. And we also, of course, have the other organizational things that help. We have courtroom technology committee that district and circuit judges sit on and make recommendations. We have a court automation committee, which works with the things like e-filing and so forth, and comes up with a recommended decision. We have the Board of Judicial Policy and Administration, on which the district judges and the circuit judges are represented, and they have a voice there. But I think if you look at it, the Supreme Court has done its best to assure that the district judges basically can go to work on their cases and not have to worry about things like getting the payroll out, paying the bills, what to do with that problem in personnel and all of these things. So as a practical matter, we're doing it and they're accepting our help.
Any additional questions for the chief? All right, thank you. Who have we not reached out to here on public comment this morning? That is waiting to speak. Ms. Sharp, Ms. Wood, I see you both are waiting. Did you want to speak?
Senator Chairman Nethercott, I just had one comment, and that is that in Bill Draft 2183 on page 2, where the LSO has set out the language of that bill draft. There is one thing that is also very important to us, and that is that that we rely on, and it provides that the technology shall be done to provide an integrated statewide system in accordance with the efforts of the Judicial Technology Task Force. That task force is no longer in existence, but instead we have a courtroom technology committee. But we rely on those statutory provisions to actually provide this, to provide e-filing, to provide courtroom technology. And so we do believe that that language is very important, and we would ask that you not repeal that portion of the statute.
Thank you, Ms. Sharp. Looks like we also, I saw Ms. Sutton, District Court Clerk Sutton, come on, and she is on our agenda. She is Teton County District Court Clerk. Is she available?
Madam Chairman, this is Clerk Sutton. I am available. My comments would be related to the next bill draft you haven't reviewed yet. I'm happy to share my comments at this time, but I thought that they would be more appropriate to follow the introduction of that bill.
Wonderful, thank you. Any additional comments on these two bill drafts? If so, if you just want to come forward and unmute yourself. Seeing that there's none, public comment is closed on the topic. Representative Gray, did you have a question for someone? No? Okay. Public comment is closed on these two bill drafts. Committee, just to break it out in a way that makes sense for us, starting with bill draft 47. What's your pleasure? Seeing that there is no action on that bill draft, that bill, or Representative Stith, if you would use your hand participant, because there's a lot of people on, so I can't see all the legislators at once, so it's hard. So use your raised hand function, and we'll start with Representative Stith.
Thank you, Madam Chairman. I think that both 47 and 83 are as drafted, since they're drafted as simple repeal bills. They are blunt instruments. And my sense is that it may not make sense to move forward with either of them today, but I think the topic, the issue is important. On 47, for example, it sounds like, according to the Chief Justice, that the court's behaving as though, and quite reasonably, the Supreme Court's actually doing all the functions of preparing the budget. They have the chief, they have the administrative capability to do it. And so in some ways, the district courts aren't preparing their own budgets. They're not separately submitting them to the Joint Appropriations Committee, and yet current law would imply that they're supposed to. I don't know that we necessarily need to act on 47 and repeal it. I think if we do move forward with 47 and adopt it, I don't think it's going to do any harm, because it's already the case that the Supreme Court's doing the work. So I'm not making a motion. I'm more suggesting if it's the pleasure of the committee to, and I know we don't like task forces, or maybe we call it something different, maybe a subcommittee of some kind. I think this issue is one that deserves to be looked at further, but I'm not in favor of going overboard on either of these bills. Thank you.
Thank you, Representative. Representative Parnell.
Thank you, Madam Chair. I think initially I voted against bringing this forward back in May. Some part of it anyway, if memory serves me right. But yeah, I really see no need in repealing some of this. I mean, if it's not broke, why change it? I think, and especially during this time of the pandemic and things of what's going on across the state. Also, I do believe in the local control. As I've you know, as you well know, the judges that the district judges that set, well, all the judges there, they're voted on by the local people, and so they should, as far as I'm concerned, remain in control. So I'm going to vote no to repeal, and I would appreciate the committee to also do so. Thank you.
Thank you, Representative Parnell. Seeing that we don't have any motion to move the bill, I think the bill will simply just not be acted on. So if there's any committee members that feel differently, just please speak up now. Again, I can't see you all. I don't see any hand raised, but there's no motion on Bill Draft 47, so that stands as it is. No action has been taken. Judge Campbell, looks like you'd like to speak.
I want to apologize about the technology.
Are you sure it's not a setup? We can't hear you.
It might be my fellow judges want to make sure I don't say too much. I'm not sure, but just with my apologies to all of you for that. Thank you.
All right, thank you, Judge Campbell. All right, with that committee, we will now move to Bill Draft 83. Any discussion or motions on that bill? Seeing none, that bill, Representative Stith?
Thank you, Madam Chairman. Similarly to 47, I think 83 is a blunt instrument, but there is an issue to be addressed, and the issue first and foremost is money. We're short on money, and yet we have district court judges who are overloaded. We have, according to the workload spreadsheet, we have some judges that are doing the work of 1.6 judges, and I have cases in front of that particular judge who by the numbers is the most overworked judge in the state, and I have empathy for him because he is really working as hard as he can to get his work done, and it's difficult for him to do, and he's crying out for help and for an additional district judge. The problem is the whole state is going to be short of money, not just this biennium, but for a very long time in the future. About half of the states have unified court systems. If you look at our workload spreadsheet, you see that there are some judges that aren't as busy. Yet right now, because of current law, there's no mechanism to even out the workload. And that's an issue. So for example, even the judge who I believe may have by the numbers at least, the lightest workload in the state is in the county next door to the judge that has the heaviest workload. And yet they're in different judicial districts. They're free to cooperate if they want to, but there's no real management of this function. And I think it's worth looking into, could we achieve some efficiencies by spreading out the workload a little more evenly across the state? That's one issue. Another issue is, and I think it's worth discussing, I can say that I believe that in the district court system, private lawyers like me are part of the problem, because our clients have an interest to take advantage of the fact that there's not really centralized management. There's not really even targets for when civil cases should be resolved. Lawyers like me, acting on behalf of our clients in good faith, I would say, do what we can to slow the system down. And that may be good for my client in a given case, but that's on the whole, across the whole state, not good for the administration of justice generally. So I want to admit that the lawyers are part of the problem here, potentially, not the government lawyers. I'm thinking more the private sector lawyers, which I'm more familiar with. The circuit court, I'm struck by how well the circuit court system functions. And it functions so well in part because it does have centralized management. it functions so well because there are rules that say you've got to resolve your civil cases in 7 months. Now, obviously, even the circuit judges need flexibility too, but to say that there should be no management of the dockets at all, I think is while it does allow each of the individual district court judges to be their own boss, and there's some value to that. I think other states have been able to have more unified systems that don't compromise the, don't impinge on separation of powers, et cetera. So having, with that long, very, very long wind up, my motion is to table 21 LSO 83.
Representative Washut, were you seconding that motion? Yes, so moved by Representative Stitt, seconded by Representative Washut to table working draft 83. Discussion on that motion, Representative Parnell.
Well, yes, thank you, Madam Chair, but I was just saying that from what the testimony was, I thought during the district judge conferences, I thought they worked out some of these issues as far as helping the judges there. But I'm willing to table it. I just said it go away, but thank you.
Thank you, Representative Parnell. Senator Anselmi Dalton.
Thank you, Madam Chair. My initial thought would have been just to take out the first line of 53102B, that the district court shall be free of administrative and fiscal control by the Supreme Court, because I think it just conflicts with the Constitution. And I do have concerns if, the county next door to us isn't coming in and helping out the workload. And I would urge the commission or judge, the district court judges to get together and maybe try to figure out how to even out the workload so that we don't have to use the hammer. I still think it's a violation of the Constitution, but I'm willing to go ahead and go with the tabling. Thank you.
Thank you, Senator. Any further discussion? Okay, seeing none, all those in favor of Representative Stitt's motion to table working draft 83, please raise your hands. And if I could get some help counting the votes here too, because there's a lot of people in this room. So if you're in favor of Representative Stitt's motion, raise your hands. I see one in the first row, one in the second row. It's 2, 3, 4, 5. Move my screen. 6. Ooh. Even though we don't have to, Mary Beth, could you do a roll call?
Madam Chairwoman, sure thing. Senator Anselmi Dalton.
No.
Senator Boner.
Aye.
Senator Koth.
Aye.
Senator Von Flatern.
Aye.
Representative Burlingame.
Aye.
Representative Gray.
Aye.
Representative Jennings.
Aye.
Representative Pelkey.
Excused.
Representative Parnell.
No.
Representative Salazar.
Aye.
Representative Stitt.
Aye.
Representative Washut.
Aye.
Co-Chairman Kirkbride.
No.
Co-Chairman Nethercott.
Aye.
I believe that would be tabled, Madam Chairwoman.
That motion has passed, as we saw. So thank you very much for the help there. All right, moving on to our next bill drafts. Mr. Fuller or Mr. Hopkinson? I think we can probably go to, looks like 83 and 82. Whenever you're ready.
Madam Chairman, I have 21 LSO 82, working draft 0.4 electronic court filings, and Mr. Fuller, I believe, has the other one remaining if you have a preference on which one we do first.
I think the district court clerks might be here for 82. So in light of their busy schedules, we'll just start with that one.
Thank you, Madam Chairman. This bill draft was requested by the committee at the May meeting. Essentially, the instructions were to kind of incorporate Wyoming Rule Civil Procedure 5E and require the courts to accept electronic filings. It creates a new subsection in Wyoming Statute 57103. And on page 2, in subsection A, we see some primarily conforming amendments being made on lines 2, lines 8. The crux of this bill draft is in subsection B. What that would require is that court clerks accept electronic filings, including email filings. It requires the original or an original document to be mailed or submitted to the court within 24 hours. It requires the clerk to note the date of the delivery of the original document. Provides that the electronic filing constitutes a paper filing for purposes of the rules. It requires that the formatting requirements be followed, and it does not apply to courts that have implemented and have available already an electronic filing system. The staff comment notes some areas that the committee may wish to consider. Specifically, it may consider adding clarifying language addressing the date of the filing when a document would be considered filed with the court, and how that would be handled if a filing is made after the court is closed for the day, as well as on days that the court is not open. It on page 4, the effective date does have an immediate effective date. And with that, I would stand for any questions.
Any questions of Mr. Hopkinson? All right, seeing none, we will go to public comment. We'll go to District Court Clerk Sutton. Please go ahead and introduce yourself to the committee and welcome.
Thank you, Madam Chairwoman, Chairman Kirkbride, and members of the committee. This is, I really appreciate the time to be able to speak to this topic. It's a really important topic for all of us for lots of reasons, most particularly given the times that we find ourselves in. I'm just going to summarize, in my view, the matter at hand. And the matter at hand, I believe, is there's an interest in updating the email filing opportunities and availability. And there's an interest from all of us to make it work for everyone. You know, we had email filing in the rules as indicated by the draft that pulled in the rule already. As you know, during the pandemic, there's been some adjustments to those rules. And I think everybody is asking, as you have been, well, where are we going to go from here? Presumably when the emergency settles down, what happens next? Is it a return to the original rules? Is it a continuation of the emergency rules, or is it somewhere in between? I think the interest from this committee that I heard, and you can correct me when I'm wrong, and I know we've heard it as clerks and all CUR partners across the state, I believe, are hearing an interest in some greater convenience and some greater availability to that email filing for lots of reasons that many of you know. But I also want to put on the table for consideration that the other matters we want to make sure we consider as we're talking about convenience and availability, it absolutely has to be a priority, and is a priority of the clerks who have been involved in discussions, that we always prioritize maintaining the integrity of the record. That can't be risked. We have to have methods and filing processes that continue to provide opportunities for a complete, accurate, and trusted record. That's of the utmost importance, and I'm hoping that everybody involved in the court system agrees with that. We also want records case management that facilitates the efficient review by judges and parties about what is happening in the case record. We want a clear case record so that the case can move forward without being overly tangled perhaps by the different choices we have with that case record management. And we also want to make sure we have realistic and sustainable adjustments that don't come with unintended consequences to workloads, workflows, and costs. So to me, that's the heart of the matter of where this discussion came from. I want to let you know, since you last met on this topic, where you voted to advance a draft bill, many court partners have been working on the same issue because it is important to all of us naturally. For example, the Clerk of District Courts Association met, had a full association meeting. We've had multiple subcommittee email filing conversations. We've had collaborations with the Supreme Court, and more recently collaborations with the Supreme Court and other court partners over this very matter, and ongoing outreach to our peers and colleagues. Where that has left us, so that you're aware, is there is great momentum and broad support for rule drafts and the existing rules. As you know, in the legislation draft you've pulled in from those rules, I think the thinking, I can say the thinking that I've had and that I've heard repeatedly is that answering the question, where do we go from here and how do we expand it? How do we make it more convenient and available without all of those risks, or with the consideration of all those other matters I talked about, would be through the rules, through the procedural matters would be addressed in the court rules where they already are addressed now, and where we are already drafting options for the civil rules, which I understand the Supreme Court would bring to the Civil Rules Committee, which notably has widespread participation by attorneys. And then from there, it's my understanding rule drafts would go to the Board of Judicial Policy and Administration. I think it's been a great, robust conversation. There's been a lot of great angles presented, a lot of good opportunities, and I just wanted to let you know that that's been happening since your last meeting. I would propose that the bill before you would not be necessary. It could be left up to that rule process would advance the updates and changes, and in a way that everything has full vetting, and we land in a spot where it's a very balanced upgrade, so to speak, and there aren't any unintended consequences that come with it, and all of the finer details and the thorny issues that need to be worked out, because it's email filing and not filing directly into an electronic case management system, that those are tended to, the matters that include acceptable signatures, confidential information protections, page limits and fees, and all of that. And I would stand for any questions.
Questions for Clerk Sutton? Senator Von Flatern is waving at me.
Yes, I am, because I always forget to turn off the purple hand. Clerk Sutton, does everybody take credit cards? Because I see on page 3, it says on line 4, together with any applicable fees. So does everybody take credit cards?
Clerk Sutton?
Madam Chairwoman, Senator Von Flatern, I believe there's lots of credit card acceptance. I can't say for certain that every clerk of district court accepts credit cards at this time. I will say that over time, it's continued to expand how many do accept them, and we continue to hear questions from clerks that don't about how we got there. So I think the momentum is in the right direction, but I can't speak that it's 100% at the clerk of district court level.
Further questions for the district court clerk? All right, seeing none. Further public comment? Go ahead and just put your video on and start your audio, and if you'd introduce yourself to the committee. Looks like we have District Court Clerk Tina Wood, if you'd like to add anything to that.
I do not have anything to add.
All right, thank you. Anyone else? No further public comment. Justice Davis?
I thought I might address this if you don't mind, Madam Chairman. I'm glad Ann went first and dealt with some of the complexities of this. You know, we sort of just immediately in our first guidance is out of
Chief Justice Davis, when will that rule be ready?
I wish I had Justice Fox here. She's the chair. Maybe Ann knows, but we are, to my understanding, they've been drafting, and I hope it won't take long. Maybe if you could recognize Ann Sutton, she might be able to tell us, because I haven't been attending those meetings.
Thank you, Chief. District Court Clerk Sutton, are you available?
Madam Chairwoman, my understanding, there is an informal working draft ready for the Civil Rules Committee to take up. My understanding is that the rule process could look like the Civil Rules Committee takes it up, the Board of Judicial Policy Administration, takes it up, and that it could be sometime around the beginning of the year. I certainly stand to be corrected by anybody else on the call who understands that process better, but my memory is that that could be the timeline. Like, as I mentioned, there already is a working draft ready for the Civil Rules Committee to take from there.
And if I might speak, Madam Chairman, I would just add that the BJPA meetings only happen 3 or 4 times a year, but the BJPA could vote by email, and as soon as that happens, the court can act on the recommendation, and I would assume it would move pretty quickly through that process and through the court. We actually, within a week, we consider almost any recommended rule change.
Thank you, Chief Justice. District Court Clerk Wood, I see that you popped on here. Feel free to chime in.
After consideration, I thought I might make just a brief statement, is that, I would really hate to see a legislative change versus a rule change, because once e-filing is implemented, then we would have to change the statute back because it would be a moot point. And so I would also like to recommend that we not go legislatively, or in alternative, use the language that Chief Justice used, as far as that, we're just doing a temporary fix until we get a final solution with e-filing. And I think with the rules, it will allow the attorneys to continue to email file and continue that practice until such time that the e-filing is in place. Thank you.
Thank you, District Court Clerk Wood. So, Chief Justice, these are the pandemic rules that are in place, right? Do you anticipate those rules being in effect for another 6 months to a year? I mean, is that the deal?
Madam Chairman, I wish I knew. These are times that none of us understand. There's no template for this. Right now, we're adapting the rules. But first, it was like, keep everybody out of the courthouse that you can. And then we went to a phase where we said, well, if you can have in-person proceedings that you can't do remotely, do that. Now we're at the point where the judges are able to have a few jury trials that they have been conducting much more slowly. And I don't know when it will lift. I check the coronavirus counts every day for our state, and they scare me. But if necessary, I mean, I think we could speed this up. I don't know when. I mean, there are no reasons that this can't move faster than 6 months. If it's prepared to be delivered to the Civil Rules Committee, I think the Civil Rules can deal with this by email, get it to BJPA, deliver it by, deal with it by email, and then get it to our court in a draft. And I would think we could get it out pretty soon. I'm thinking a month or two. And I guess I don't know that the pandemic rules are going to be changed in that period of time. And I guess we could also leave that piece, we can leave that piece in effect, the email filing. It is kind of a pandemic related effort to reduce people walking into the clerk's office.
Thank you, Chief Justice. Any questions for the Chief Justice or the clerks? All right, any further public comment? Judge Christensen, I see you're joined us. Good to see you.
Thank you, Madam Co-Chair Nethercott, Co-Chairman Kirkbride, members of Joint Judiciary. My name is Brian Christensen. I'm a Circuit Court Judge here in Natrona County, President of the Circuit Court Conference of Judges. Just a few quick comments as to Senator Anselmi Dalton's question earlier. The Circuit Courts will be ready to operate with electronic filing when made available. And to my knowledge, we've never opposed e-filing, electronic filing at all. So once that's made available, we are ready to go forward with that. Natrona County is the busiest civil docket in the state of Wyoming, and it's because of collection cases and our regional medical providers located here. We've had just in fiscal year 2018, 5,500 collection cases filed. We've been doing email filing since the time of the COVID pandemic period. And there are huge differences between electronic filing and email filing. You're talking a software program versus a message service. And because of that, we have already been working on rules, which the district court clerks have been working on, and we recently have been invited to their meeting to help coordinate consistent rules throughout the judiciary system. But as you can imagine, you're going to need rules with these a lot more stringent than with electronic filing. Like, when is a filing actually filed? When somebody puts send. And we've had this issue where we did not receive the originals, we did not receive payment for printing them off, or the fees, and then finally had to track back down, and they go, oh, well, we decided not to file that. So we, counting pages, printing those off, replacing those with originals that may never be received. Even if they sent them within 24 hours, they may be delayed. Redactions and working with confidential information, service copies, and then possible viruses attached to attachments, hacked or falsified emails. So there's work here, but we're way down the field on working with these. And I just want to reiterate, I think it's kind of been alluded to, but I don't believe we need a statute, because we're working on them now, and we're going to need these rules going forward before the electronic filing becomes available. And I think the only other comment I had from the morning was I'm not sure Representative Washut probably already sent me an email, but no, I've never had to count toilet paper.
Good to know, Judge Christensen. We're thrilled to hear that, I think. Your time is spent doing the job you have been asked to do for the people of Wyoming. So any additional comments from anyone else or questions for the Circuit Court Judge? Chief Justice.
I just had an email from Justice Fox, and two things. She says they will definitely have that, the rules, their rules process will be done before the end of the year. And she wanted me to make clear it's actually an amendment to Wyoming Rule of Civil Procedure 5 that we're talking about. That's all I have.
Thank you, Chief Justice. All right, Representative Stith, questions for these folks?
Madam Chairman, Judge Christensen, I noticed you mentioned that when an email filing comes in, then it appears that your office or the clerk then prints it out. I spoke with another circuit court judge recently who said the same thing. And my question is, if you get an email filing, do you need to print it out?
Judge Christensen?
Madam Chair, Representative Stith, we've operated both ways. If we have one of our major collection agencies send us multiple filings on multiple cases, going back to find that email is almost, well, it's more time consuming than actually printing it off to go back and search for that email. And then trying to match up printing fees for that. There's a myriad of issues, but you would have to take time if you have multiple filings from some agency that come on separate emails, then trying to locate those. If you don't print those off and have them associated to a file already, which is at this point easier to identify than to go back through a long list of emails from numerous agencies and attorneys, and how those records are stored and the emails stored in and of itself. Where do you put those? Do you delete those? There's all kinds of questions.
We are running out of time. I just want everyone to be mindful of that. District Court Clerks, I see you both popped on. I definitely want to answer that question about why aren't you saving them electronically? Of course, there's a statutory obligation requiring you to keep that record and get it to state archives, but I'm happy to hear your thoughts on that. We'll start with Clerk Sutton.
Madam Chair, Representative Stiff, this is one of those thorny issues that the groups have been working on. Again, I mentioned it previously in my comments that we want to make sure we move forward without unintended consequences. Judge Christensen highlighted one of the workflow and workload issues. And Representative Stiff, I think one of the important things for clerks is, do we have the authority to accept the email filing as a standalone filing? And I think one of the questions I've heard from that is, well, what are the appropriate signatures that would be accepted and what wouldn't be, in the interest of making sure it's a trusted document and all of that. I think there have been some great proposals included in the informal working draft that are vetting those and hopefully achieving efficiency both for the filer and also for the clerk receiving the record, and that I believe could avoid the unintended consequence of having to double process the same item, which I think is your observation and point.
Thank you. Clerk Wood?
To answer that question, the courts are not paperless, and just when they come in via email as a PDF or we have to have them as PDFs, we have no ability to file stamp them. So we need to print those and file stamp them and then scan them back in. So there is a file stamp on that copy that is the official record. Thank you.
All right, any additional questions from the committee? All right, seeing none, public comment is closed. Committee, what's your pleasure on the bill? Representative Pelkey. Representative Pelkey, did you have your hand up? No, okay. Representative Gray?
Yeah, I'd like to move the bill.
Moved by Representative Gray, seconded by Senator Anselmi Dalton.
Second.
All right, discussion on the bill. Representative Gray.
Madam Chairman, do we have that amendment that the Chief Justice, the rulemaking amendment, could we bring him in? Is that inappropriate?
Only if you think it is, Representative Gray.
I don't think it is.
All right, Chief Justice Davis, if you could retell us what your proposed amendment is, that would be helpful.
Sure. This is not necessarily a thing of beauty, but what I sketched out was, quote, the clerk shall accept all papers filed, signed, or verified by electronic means, including email, comma, in accordance with rules to be adopted by the Wyoming Supreme Court no later than, and then you would want to insert a date.
All right, thank you, Chief Justice. Representative Gray, would that be your motion?
Thank you, Madam Chairman. I mean, I guess the question would be, what are we deleting then in there because you got to delete some stuff to replace that with that. I don't think you can just do an addition. Hold on.
Mr. Fuller?
Okay. Representative Gray, the way I understand it is that looking at the bill on page 2, line 23, after email on that line, everything, so any paper, and then basically all the new language on page 3 would be deleted, if I understand the Chief Justice's intent with his amendment, or with his proposed language, that is.
I think that is correct. And then, so Representative Gray, do you think that's correct? I see the furrowed brow.
I was more thinking that replaces lines 1 and 2 on the bottom of page 2, and the rest could remain. But and we could say, I think the rest of that is okay, and you create rule to execute it in entirety pursuant to the rest of page 3, and I think that do you agree with me, Mr. Fuller, that it would work if you just use that, if you replace lines 1 and 2 there with the amendment?
Chairman Ellicott, Representative Gray, the way I understand it is, I think the way I understand your intent would be to add the language after email on line 23, and then basically leave the rest of it as is. And in terms of your question, whether that would work, I think the idea then would be the rules would be based on those other prescriptions that are listed in the remainder of that subsection.
Madam Chairman, Mr. Fuller, did you get the full? I was trying to write this down, and did you get the full amendment? Can you read it out again?
Yeah. Chairman Ellicott, Representative Gray, I guess with allowance for, minor changes, I think the way it would read is beginning on line 22, the clerk shall accept all papers filed, signed, or verified by electronic means, including email, as provided or in accordance with rule of the Supreme Court to be adopted not later than a date, period.
Yeah, thank you, Mr. Fuller, Madam Chairman.
Representative Gray.
Yeah, I think we can keep the rest. So my motion would be to delete lines 22, lines 23 up to the period, and replace it with Chief Justice Davis's suggested language, and we insert the date for the rule as April 31, 2021.
That's fine with me, Madam Chair, as a second, and unless we think the time period should be shortened, I don't think it should take them that long, but maybe I'm wrong.
Okay, that was a friendly to the second. Further discussion on Representative Gray's motion. Representative Stith.
Madam Chairman, it just can't be April 31. It could be April 30th.
Thank you, Representative Stith. Representative Washut, was that your comment as well?
No, Madam Chair.
Okay.
My comment is, what if the rules adopted don't line up with the remainder of the statute's new language? I think there's a potential, at least, for a conflict if we retain the rest of that new language and the rules don't jive with what we're putting in the statute.
Yeah, it's unfortunate that it's taken so long for rules to be crafted to discuss this issue, so that it's going parallel with legislative action. Certainly creates a conundrum. Further discussion? Representative Gray?
Thank you, Madam Chairman. My response to that would be that, like any rulemaking authority at the federal or state, local level, they would need to craft the rules around law. And I think that's fine. I mean, I think they would adjust. We give them a month and a half to, if their rule that they had before the passage of the bill was a little different, they could craft it. But I think what the rest of page 3 does is ensure that it is the vigorous email system, that you have a complete filing, that it isn't ticky-tack or whatever word you want to use there, that it is a complete email filing. And that's why I think we need to retain that, not just have a broad 2-sentence thing saying we're just going to have open it up for rulemaking authority to have email filing.
Representative Parnell?
Thank you, Madam Chair. Just my suggestion, maybe we should also table this bill and have a little more update on our next meeting as far as the what I can see a little confusing on that, but I would be willing to table the bill at this point and would move to do so.
Thank you, Representative Parnell. Any further discussion on Representative Gray's motion? Is everyone clear on what Representative Gray's motion is? Seeing that you are and sensing that you're ready for the question. All those in, yeah, Representative Washut?
Point of order, Madam Chair. I think the motion for table supersedes Representative Gray's motion.
Is there a second to Representative Parnell's motion to table? Senator Von Flatern? All those in favor of Representative Parnell's motion to table, raise your hands. We're going to do a roll call on this too, because I can't realistically count in 2 screens with 40 people on.
Madam Chairwoman, this is a roll call vote on the motion to table. Senator Anselmi Dalton.
No.
Senator Boner.
No.
Senator Koss.
Yes.
Senator Von Flater.
Yes. Aye.
Representative Burlingame.
Aye.
Representative Gray.
No.
Representative Jennings.
No.
Representative Pelkey.
Aye.
Representative Parnell.
Aye.
Representative Salazar.
No.
Representative Stith.
No.
Representative Washut.
No.
Co-Chairman Kirkbride.
No.
Co-Chairman Nethercott.
No. Okay, back on Representative Gray's motion to amend the bill and seconded by Senator Anselmi Dalton. Further discussion on that motion, Representative Washut.
My recommendation is that the date certain could be the start of the session. And that way, if the rules are promulgated prior to the session, we'll have an opportunity in January to address the differences between the rules and the statute.
I'll second that.
So are you making a motion to amend Representative Gray's motion to change the date from April 30th to the start of the session, which would be, what do you want to make that?
Yes, that'd be my motion to amend, if it would be friendly.
Give me a date certain, Representative Washut. Representative Washut, do you have a date certain?
How about January 3rd, 2021?
Representative Gray, do you find that friendly?
Yeah.
Senator Anselmi Dalton, I assume you do as well.
It's friendly.
Representative Pelkey is raising his finger. I assume he wants to speak.
Yeah, I'm just curious if, I mean, I don't think it makes a lot of sense. I mean, if this bill is drafted, it's going to be passed in the 2021 session. In essence, what we would be doing is retroactively imposing a limit. And I would think that we are efficient enough to work with the judiciary in drafting those bills during the session. So I would suggest not to vote for setting a January date, and either immediately after the end of the 2021 session, or perhaps the original April date.
Senator Boner?
That was my comment as well, Madam Chair.
Further discussion? Representative Gray?
Thank you, Madam Chairman. I think I do agree that it would probably work better to have the rulemaking after the enactment of the bill. I mean, I think we can just build page 3 around whatever rule they come up with, and we could do that during the session. I do think the other way is a little bit better. We can go either way, but I guess now the motion has changed. I don't know, Representative Washington, if you're interested in withdrawing, but anyway, I think it probably is better the other way, but I'd be curious to see why, Representative Washington, you think we should go this direction, but I just want it to work.
Good efforts there. Representative Washington, if you'd further explain the purpose of why you want the January date.
Well, my thought was if we pass a law in the session that has contrary guidelines or statutory language that is different than the rules that are promulgated, if we could get the rules promulgated before the session, then I'm not sure we even need a statute. But if the rules follow the session, then the committee that's putting the rules together could spend a lot of time drafting rules that then need to be amended to conform with the statute that we passed in January.
Senator Cost.
My concern would kind of be the other way. If they spend a lot of time on the rules and then the bill doesn't pass, that seems to be a waste almost the other way. So I'm wondering if we need to get the bill passed.
I'm going to say I am hearing a number of challenges in hearing from a number of you. I think it might be your locations, but where you do go silent or you're on audio. So some technical challenges. Don't know if other people are hearing that, but just let everyone know. Senator Boner?
Yeah, thank you, Madam Chair. Just to reemphasize, I think what Representative Pelkey was trying to point out, just from a procedural perspective, it makes absolutely no sense to require rulemaking in a bill that precedes the enactment of the bill. It has no force of law. Therefore, I understand that the desire to have the rules, become effective before we consider the bill draft, but there's no force of law. You can include it in the bill, but it's not going to do anything. So it's the first time I've ever heard of trying to force rules to be promulgated before the bill is effective. It makes no sense, and we just need to. I think Representative Washington, I understand what he's trying to get done, but there's just no way to do it without the bill actually becoming law. So we have to have the rulemaking after the effective date or concurrent with the effective date. There's just no other way to go about doing this. So I just ask that Representative Washington really consider withdrawing his amendment.
I would say this, committee, these are my thoughts. This is a little out of line, but from where we are and kind of blending all of our concerns, what I heard from the clerks is that they do have an informal working draft of their rules prepared and ready to submit to the courts committee. And so going back to, I think, Representative Parnell's desire to maybe give a little bit more time to that process, how does the committee feel about keeping the bill as currently presented, having it on our agenda at our October meeting with the request from the clerks that they provide that informal working draft that they have for us to review and look at? And that way we can evaluate the process more, but we're not taking them off the hook. So I would vote no on this amendment, just keep the bill as written and wait for an update at our October meeting. Representative Washit.
In the interest of time, I'll withdraw my amendment to Representative Gray's motion.
Representative Gray, you find that workable, Representative Gray?
Yeah, thank you, Madam Chairman. Yeah, I'd like to move forward with my amendment. I think we are, one thing that we haven't gotten into in the discussion is I think the rule, my understanding of this, I did not ask it, is that the rule is going to make this email filing optional. So it'll be optional. The statute makes it mandatory. And I think that's a policy question. And I lean towards this should be allowed. And it should be done across the board, across our state. And so I think to just say, well, we're going to let the rule fly. I think there's a policy question even with the rule, because I think the way the rule will be written, it'll probably be optional, and it'll be how it would work if they opt to do it. And I think we need to move in this direction and make it happen. So I still think the bill is important.
All right, for further clarification, Representative Gray, and for the committee, what is your understanding of the date in your motion now?
Yeah, thank you, Madam Chairman. I would like to amend my motion to make the rulemaking April 30th at the end of the bill, April 30th, 2021.
Your second, Senator Anselmi Dalton, finds that acceptable. So is everyone clear on the motion? Representative Washit, your hand is still raised. Anything further? No. Okay. Mr. Hopkinson.
Thank you, Madam Chairman. Just one thing to keep in mind as well. There could be some separation of power concerns when we instruct another entity to promulgate rules and then tell them what those rules should say. So that's just something I wanted to bring to committee's attention, not commenting on whether or not that's the case here, but that could be a concern.
Thank you, Mr. Hopkinson. All right. Seeing no further discussion from the committee, all those in favor of Representative Gray's motion, roll call vote, please, Mary Beth, because I just can't feasibly count 60 people. There's 60 people on.
Madam Chairwoman, this is a roll call vote on Representative Gray's proposed amendment with the date change. In addition, Senator Anselmi Dalton.
Aye.
Senator Boner.
Aye.
Senator Koff.
Aye.
Senator Von Slater.
Aye.
Representative Burlingame.
Aye.
Representative Gray.
Aye.
Representative Jennings.
Aye.
Representative Pelkey.
Aye.
Representative Parnell.
Aye.
Representative Salazar.
Aye.
Representative Stith.
Aye.
Representative Washit.
Aye.
Co-Chairman Kirkbride.
Aye.
Co-Chairman Nethercott.
Aye.
That passes.
That motion passes. So back on the bill, committee, what's your pleasure on the bill? Representative Stith.
Madam Chairman, I would propose an amendment as follows. On page 2, line 23, after the period, after the completion of that sentence, insert the following. The electronically filed document shall be deemed an original and no physical original needs to be filed, period. And then I would delete from the current draft the clause beginning on line 23, or the sentence, the first portion of the sentence on line 23 that begins with any paper filed by electronic means shall be followed by an identical signed or otherwise duly executed original, through through the word with on line 4. And then to make it grammatical, we would add the word at the end of line 4, after the word rule, you would add shall be, so that the effect is that electronic filed is deemed an original, delete the paper requirement, and then as a separate sentence, you say any applicable fee set by statute or rule shall be mailed or submitted within 24 hours of the electronic transmission.
Is there a second? Seconded by Anselmi Dalton. Discussion on Representative Stitt's motion. All right, seeing none, all those in favor of Representative Stitt's motion, roll call vote. Mary Beth.
Senator Anselmi Dalton.
Aye.
Senator Boner.
Aye.
Senator Cost.
Aye.
Senator Von Flater.
Aye.
Representative Burlingame.
Aye.
Representative Gray.
Aye.
Representative Jennings.
Aye.
Representative Pelkey.
Aye.
Representative Parnell.
Aye.
Representative Salazar.
Aye.
Representative Stith.
Aye.
Representative Washit.
Aye.
Co-Chairman Kirkbride.
Aye.
Co-Chairman Nethercott.
Aye. All right, committee, we're back on the bill. Further discussion on the bill?
Question.
Question being called on LSO Working Draft 82 as amended. Roll call vote, Mary Beth.
Sure. Senator Anselmi Dalton.
Aye.
Senator Boner.
Aye.
Senator Cost.
Aye.
Senator Von Flater.
Aye. Aye.
Representative Burlingame.
Aye.
Representative Gray.
Aye.
Representative Jennings. Representative Pelkey.
Aye.
Representative Parnell.
Aye.
Representative Salazar.
Aye.
Representative Stith.
Aye.
Representative Washit.
Aye.
Co-Chairman Kirkbride.
Aye.
Co-Chairman Nethercott.
Aye.
That passes then.
That bill has passed. Committee, we obviously are running really late on our schedule. We have one more bill to review. We have not had a morning break, and we're just going to power through till lunch in light of how far behind we are. So feel free, as I believe you know, to take those breaks. So we are now on LSO Working Draft 48, Judicial Workload Assessments. Mr. Fuller, if you can walk us through the bill.
21 LSO 48, the committee requested this bill, which would require the regular completion of judicial workload assessments for each district court and circuit court, as is currently being done. So on the bottom of page 1, beginning line 12, this new section would say that not later than October 1st, 2021, and then each October 1st that immediately precedes a budget session, the Supreme Court must complete or have completed an assessment of workload for each district court and circuit court. There's a staff comment on page 2 that just notes whether the Chancery Court should be included in this statute that would require workload assessments. On page 2, line 17, this just outlines what the assessment must include at a minimum. Weighted workload calculations based on annual filings by case categories, calculation of the total judicial workload for each county and each judicial district, the need for judicial services for each county and judicial district relative to the number of judges assigned, and then page 3, line 4 is any other information that the Supreme Court requires that be included in that study. And then page 3, line 7 just states that before the date or on the date that's specified, October 1st, the Supreme Court must submit the results of that assessment to this committee. and the report must highlight whether the assessment shows that there is a need for additional judges, or there's that the workload is such that fewer judges are needed to complete that workload within a district based on judicial need. And then the language on page 3, line 16, this is, other states have included this. It just says that the committee can sponsor any legislation in response to the assessment. The committee can already do that with the assessment it receives. So whether that language is necessary to include is up to the committee. And then this bill draft would be effective immediately. The upshot being that the workload would still be due October 1st for the first time. With that, I'm happy to stand for questions.
Questions of Mr. Fuller? And we'll focus this on Mr. Fuller. Remember, we'll hear from the court and others as it relates to the need and costs associated with some of these concerns. Co-Chairman Kirkbride.
Thank you, Madam Co-Chairman. Mr. Fuller, in particular, looking on page 2, subsection B, what of those requirements are different than what is already being done? Are we adding much to that information we've already been receiving, or is it just pretty much what they were doing already?
Mr. Fuller?
Chairman Nethercott, Chairman Kirkbride, I believe that what is captured, what is listed here is what is already being included in the study. But I would defer to the court to confirm that for sure.
Senator Von Flatern.
Thank you, Madam Chair. Mr. Fuller, does this mean that we always have to schedule an after October 1st meeting for the Judiciary Committee?
Chairman Nethercott, Senator Von Flatern, I guess that depends on the will of the committee. Going forward, whether the committee wants to have a meeting to, be sure to account for these results, before a budget session were to take place. There's nothing in here that says that they have to or they don't. So I think that would just be up for subsequent committees to decide how to proceed in that regard.
Thank you, Mr. Fuller. Any additional questions for Mr. Fuller? Co-Chairman Kirkbride? Still have a hand up? Good. Okay, with that, we'll go to public comment. Our Representative Gray has a question for Mr. Fuller.
Thank you, Madam Chairman. Mr. Fuller, it sounded like you had looked at some other states, how they handle the workload issue in drafting this. Do any states prorate pay based on workload?
Mr. Fuller?
Chairman Nethercott, Representative Gray, the study that that my colleague completed that was reviewed did not look at that issue, nor have I looked at that, but I'm unaware of any state that bases salary or prorates salary based on a particular workload of a judge.
All right. We'll go public comment at this time, and we'll go to the court probably first. I think we have Ms. Sharp available. And of course, Chief Justice and Ms. Butler, looking through the list here. Any of you who'd like to come forward and make some comments on this? Chief Justice?
If I may, Madam Chairman, thank you. With regard to weighted workload studies in general, I just would like to begin by pointing out that our branch has been using those since 1999. We have quite a bit of experience administering them, and we have always intended to continue to use them with occasional use of appropriately qualified outside consultants. Just a quick refresher from when we met last time. The weighted workload studies begin with what we should probably call a time study. Anyone subject to the study, which would be the judges, and in the circuit court, that would include the clerks, they have to record their time, the time they spend on each task for a period of 2 to 3 months, kind of like lawyers record time and for billing. We would prefer to do a time study every 3 to 4 years using a statistician, but it's been historically longer due to funding issues. We have used a statistician who was formerly with the National Center for State Courts. I guess she is now retired after being in business for herself for a while, so we've got a new consultant. Anyway, the person who does this review, as they do for many courts, develops a weight for each task. Judges and the circuit court staff do, just using the knowledge and the statistics that are in use and the knowledge from other courts. I do want to point out this is not free. Last budget session, we asked for $240,000 to cover the cost of a time study for just the circuit courts after we complete the upgrade to the new case management system. And we need to measure workload with that system, which has some changed requirements for the clerks, particularly with scanning. Unfortunately, the Joint Appropriations Committee did not approve that expenditure. But if you're looking at costs, I think you can figure out about $250,000 to $300,000 for each court level for each time study that has to be done. The good news is that once we get those weights for our cases, our staff can in subsequent years just pull case numbers and use the statistical workload to come up with the study that you see because it's simple arithmetic. However, the time studies need to be repeated periodically as the workload changes. Just to give you an example, the legislature passed the self-defense immunity statute, and that requires some additional hearings by the district court. So that would affect their workload. Now, if I may, to the bill itself, it would require a study every year beginning in 2021. And I have been told that I need to convey some things about that. There would need to be a periodic funding component to allow for updated time studies, because eventually the times that just plugging in the numbers doesn't work anymore due to caseload changes. As to practical issues at this point, in the circuit court, we are in the process of updating the case management system. Right now, some of the circuit courts are on the old system and some are on the new system. And we expect to get them all on the new system by February. We had hoped to get that done earlier, but the pandemic has had its impact on operations and training. But here's the catch. The new case management system has much more precise case categories, which is a good thing. It'll allow us to be more precise in our numbers. So that's an improvement. But the old system is still on the old ones and they don't talk to each other in that sense. It's just not possible to mix those. And since we're measuring work for the clerks and everybody else, the system's important. Second thing is that in order to get reliable case weights through a time study, we need to allow the courts to have some time to get used to the new system and develop a track record with it. There are always issues at the beginning as the clerks learn the new system. These are complex programs. And it's best, I am told, for there to be a full year or more of experience across the level of the court that we're studying. Now, you may say, why don't you just take half a year and double it? That's what jumped into my mind, or maybe a fourth of a year and quadruple. What I'm told with regard to the circuit courts is that the load of the circuit courts is cyclic in the year. So I think you can see in the fall, guess what? There are a lot more game violations than you would see at other times of the year when there isn't hunting season. In the summer, there are more tourists getting traffic tickets, we hope, because that's where we get funding for a good piece of our court. And there are probably other seasonal variations. And if Judge Christensen is still with us, maybe he could talk about those. The bottom line is that it probably isn't possible to get a valid workload study for the circuit courts until late 2022, contrary to what the bill would require. As to the district courts, we can get one more weighted workload study done by using the existing time study data and caseloads before we start upgrading the case management system in the district courts. I wish I had Mr. Nicholas's chart, but that will happen next year, but we can squeeze in one. Once we start piloting the new district courts on the case management system, we'll be in that same situation we are now with the circuit courts, with part of the district courts on the old, part on the new, with different case types. They will be more accurate case types, but you have to have them all on the same. You can't mix them. In addition, we hope to start piloting e-filing before all the district courts are on the new case management system. The clerks of district court have not warmed to that idea, but we're hoping that with the excellent e-filing contractor we have, we may be able to persuade them, and maybe we'll have some good experience with the Chancery Court if that goes forward. Anyway, it's the same as with the circuit courts. It'd be best to have a year of data to assure the system is being properly operated as to case types, et cetera. Now, this would be just judges in the district courts because the clerks of district court don't figure into our time studies. They're county employees, but it does reflect on them because they probably identify the case types, and hopefully the judges review that. So I guess what I'm saying at the end of the day is we have no intention of ever not doing weighted workload studies and making them available to the legislature and the public. Ours are on our website, and you can look at them whenever you like. We've always done that. But at times, like in the near future, we may not be able to make that happen on an annual basis in accordance with the schedule in the bill. And that's all I have, Madam Chairman.
Well, thank you, Chief Justice. Very helpful. Kind of going back for the district court judges who may be listening and wondering why this is happening, and everyone else. Just for our memories or recollection, this was kind of my push as a result of managing kind of the random requests for the addition of additional district court judges across the state. And what I've observed happening historically, which is where the local judges in that district, ask their senators or representatives to bring a bill to add another judge. And it's kind of this individually sponsored effort. And no one really knows the situation. And it just kind of becomes this, they're really busy, they're overworked, and they need another judge in that area. And we do have the workload studies to assist in that effort. And that there was no real process in place for the legislature to evaluate the need for additions or reductions of judges in certain areas. And so it was my hope, not necessarily to do an unfunded mandate on the court, or probably even to do these kind of studies this frequently as indicated in the bill, but to at least put a process in place that allows for the regular review by a legislative committee of oversight of the judicial workload, and if that really is serving the citizens of Wyoming that in a way that administers justice effectively, both with time and resources and money. And so that's the goal here. And so any feedback you have about modified timeframes and types of studies, I think, are important, and certainly not my intention to require, costly studies that aren't, really that particularly effective at any particular time on a regular basis. So I just would like to share those intentions. It's really in an effort to create a long-arm transaction for how this process looks. Representative Washut.
Thank you, Madam Chair. Mr. Chief Justice, my question is, on an intuitive level, is it not possible to get a pretty good sense by some numerical indicators of how busy a particular court is without having a judge track every 15 minutes of his or her day?
Madam Chairman, Representative Washut, I guess the experts on courts would say that that's the best way to do it. I mean, this isn't something we invented. It's done by courts across the nation for the very same reasons that we need it here. I mean, there are those who say, well, you could just say for every 30,000 people, you need another judge. So if your community is hovering around 50 and you pop over to 60,000, some people would say, well, there's where you need to look at another judge. That's not really informative. If you have peace-loving and non-litigious citizens in your 60,000, maybe you don't get there. If you're talking about Teton County, maybe you need even more. I don't know. because of all the litigation there. But this is just the best way that we know to do it. And I feel really fortunate that when I was a district judge, I managed to get appointed to the Supreme Court before I ever had to do one. I had plenty of writing down every minute of time I spent when I was a lawyer doing mostly insurance defense work. But anyway, that's what we've been doing, and I think it's yielding pretty good data.
Thank you, Chief Justice. Any further questions for the Chief Justice before we hear from Ms. Sharp or Ms. Butler? All right, Ms. Sharp, do you have anything to add?
I'm just going to turn it over, Chairman Nethercott. I'm going to turn it over to Elisa Butler just to explain a tiny bit about why we do use these studies, and we're actually will be really excited when we can afford another time study, because we're moving to a national statistical analysis that is consistent with the National Center for State Courts, and we believe will be even more accurate than the time study and the work study that we've done before. But Ms. Butler is the expert right now on our court statistics and has worked closely with Rhonda Munger on the weighted workload study. So I'll turn it over to her.
Wonderful. Munger, yeah, feel free to just come forward. And Ms. Butler.
Madam Chair, Mr. Co-Chair, members of the committee, my name is Elisa Butler. I'm the General Counsel for Court Administration. I don't know that I have much to add with what the overview that the Chief gave you. I will tell you he did mention that we will have more specified case types with the new system, the new case management system, which is called Full Court Enterprise. And we, as he mentioned, we have nearly rolled that fully out in the circuit courts, and we'll begin that in district courts next year. And what that will do is it will allow us to more accurately compare the case filings in Wyoming with case filings across the nation. In Wyoming, we've been pretty unique in how we have case typed all of the filings in the courts. And so we're trying to move toward a model that will be more consistent and more uniform with the rest of the nation moving forward, so our statistics more accurately line up with other courts and other jurisdictions. We do use the workload study heavily in terms of telling us where we have need in the courts throughout the state for judges and circuit court clerks. So it is a valuable tool that we use. I do believe in looking at the bill draft that we do provide all of the information that is listed already on our website, and we would be happy to give that information to you periodically as you request. So that, and if I would stand for any questions.
Thank you, Ms. Butler. Representative Gray.
Thank you, Madam Chairman. Ms. Butler, the 2019 study that we got last year, I think I wrote down as $240,000. Was that a 900 series expense?
Madam Chair, Representative Gray. So we have not done a new study, time study for the circuit courts. We need to. The study that we had previously is now basically moot because of the new case management system that we're rolling out in the circuit courts, as the Chief mentioned. So we didn't actually receive funding from the joint appropriations for that $240,000. That was denied as a request during the last budget session. So we don't have additional funding to do that study at this current time.
Follow up, Representative Gray.
Thank you, Madam Chairman. So did you not move forward with the study at all, or did you pay for it in your own budget? Because we got that one last year, remember? But if my recollection is you guys said that you did that internally and you just did it on your own, and it was a little bit more statistically less. But did you do that with outside work, and how did you pay for that if you did?
Ms. Butler.
Madam Chair, Representative Gray. So I believe if you got a workload study in 2019, the workload study that we provided was for the district courts only. And that was based on the time study that we did years ago. So we have not done an updated time study in the district courts or the circuit courts for a number of years. So we haven't paid for one. So generally what happens is that time study and the development of the workload study, the payment for that comes in on the front end. And so we paid for that a number of years ago. And then after that, we just do our own math. So based on the weights that are given to each case type, we just plug in the number of filings for each one of those case types, and that's what gives us our workload study. So we don't have to pay for a new time study every year, although it is recommended that we do that, I believe, every 3 to 4 years, just to make sure that we maintain the accuracy of those studies moving forward.
Co-Chairman Kirkbride.
Thank you, Madam Co-Chairman. So Ms. Butler, on into the future, if we're obligating you to produce one of these studies every other year before the budget sessions, are we looking at $250,000 each time? Or Ms. Sharp alluded to some of this information will almost kind of be collected by the system and may be much easier to produce on down the road.
Ms. Butler.
Madam Chair, Mr. Co-Chair, so it will not be, I don't believe we will need an appropriation every 2 years for the weighted workload study. We will need an ongoing appropriation if this is going to become a requirement of the legislature. And that is simply because we do have, as we move to new systems, case management system, e-filing system, as we have changes in the court structure. So for instance, when the civil jurisdiction of the circuit courts was raised, those all affect the weighted workload study and the numbers that we will be able to provide to you. And so as we change those things, the weighted workload study that we currently have becomes moot, and we will need to prepare a new one. So we will need an ongoing appropriation to make sure that maintains its accuracy over time. But I don't believe it will be an appropriation every 2 years.
Representative Jennings, or I'm sorry, Ms. Sharp had follow up to that, answer that question, then we'll go to Representative Jennings.
And this is just to clarify. Just to clarify, so what happens is, and it's similar to the studies that you have done for education. What actually happens is an expert, and you're right, Representative Gray, the year that we have the study, we'll use the funding. It'll be in our 900 series. We will most likely, the company that does this the best, or the organization, is the National Center for State Courts, and they would come and they would spend about 3 months working with our judges in whichever jurisdiction we started in, which would likely be the circuit courts, because they have their new case management system will be fully rolled out. So after they have been on that system a year, then the National Center would have the judges keep a time study of every type of case they do. And then that time study, with that, what happens is the National Center then builds a model. And for example, they determine that for a collection case, it may take a circuit, or it should take a circuit court 5 hours, for example, or 10 hours to complete that collection case. So once the model is built that we pay for, which is about $250,000 to have the National Center come do the study, build the model, then they give us the model. And then we can plug those figures in every year, but every so many years, like for example, every 3 to 4, or at least every 5 to 6 years, then it is beneficial to have the National Center come back and do another study, because the methodologies change. So it's very similar to what you do with the Department of Education. The only thing is we don't have to pay. We can do the work for several years until the methodology needs to be upgraded.
All right, thank you. Representative Jennings.
Thank you, Madam Chairman. So on page 2, if I'm hearing you, I'd just like, this is probably Ms. Butler or Ms. Sharp. On page 2, where we're talking about the workload assessments, and yet I hear you talking that we're going to move to a new system. If we put this in statute, will we have to come back and repeal this or change the wording for whatever your new system is?
Ms. Sharp.
Chairman and Representative Jennings, Yes, I believe what we want to absolutely provide this for you. We cannot provide the first time study. We would not be able to conduct until our circuit courts have been on the new system for a year. So the first time study could begin, that is, having the National Center come here and work with our judges for about 3 months. That could begin in 2022. And so we absolutely want to work with you. What we would suggest is that you also table this bill, allow the circuit courts to be on the system a year, and then we will come back to you and we can come back to you in the interim and we could actually have the National Center come and speak to you and explain what they would do. And we will have a proposal from them as to how much it will cost for the circuit courts. And then in a year from now, we can tell you, we'll be closer to knowing when the district courts will all be rolled out on the new case management system, when they will have had that system for a year, and then when it is feasible to do a case study, a new workload assessment, and actually a new time study for the district courts. And we apologize that we can't do it sooner, but it is basically because we are moving to new case types. And those new case types will take a different number of minutes for each judge to complete.
Ms. Sharp, kind of going back, I find these studies necessary and important, and obviously we must continue doing them. But going back to kind of the purpose of the bill, which was to avoid 2 other bills that we saw before, is do we need an additional judge in Uintah County, and do we need an additional judge in Campbell County? And in this next session, are we going to deal with 2 bills from legislators asking for those additional placements of judges? So I appreciate the effort and focus on kind of the technical nuances about gathering the data and what the report looks like and whether or not it's a weighted caseload study or not. But from my perspective, what the effort, at least for me, trying to solve is, what does the ask look like for the addition of a judge? What really does that look like? And so, because I was, we know, and I go back to this, I was dissatisfied with just a very powerful legislator has taken care of it in the past. And that's how we got new judge positions in the state. And that worked, but maybe it would be prudent to have more of a process associated with that was based on these workload studies that the court is already doing. So I don't want to overemphasize the importance of the way the information is gathered and the type of study that is conducted, certainly important. But I kind of want to go back to the big picture of, do we need judges, and what does that look like, and what does that look like? And you don't need to answer that right now, but that's kind of the focus of the topic, as opposed to those technical.
Another cut.
Yeah. Go ahead, Ms. Sharp. Yeah.
I understand completely, and we have already, and Rhonda Munger is not here today. She had the gall to go down the Grand Canyon, but she has done a study for this year, and I'm going to turn it over, if you don't mind, to Judge Fenn, because I think he can answer these questions better than I can in light of the workload and we are talking about the workload in Sweetwater County as well as in Campbell County and in Natrona County. Judge Fenn?
Okay, I just want to caution, we are an hour behind schedule. So we got to keep this, if we're going to all be out of here at a reasonable time and get to the rest of the work today. We've got a bunch of members of the public waiting to speak. We have 24 waiting to come in on additional topics. So I want to just be timely about this, but Judge Fenn, look forward to hearing from you.
Thank you, Chair Nethercott and members of the committee. Your concern is very legitimate, and I'm kind of the poster child on this because for the first 6 or 7 years I was on the bench, I was the busiest judge in the state. The numbers reached almost 1.8 judges, and I was overwhelming. Well, then we get a new judge in Johnson County, Judge Edelman, and so that kind of cut my workload in half. And the promise was made, and I think it's been kept, that we will help out other districts, and we do that. But going forward with respect to the study was an important part of that process. I also did a lot of analysis with respect to population and other statistical analysis to support that. But you have this kind of a stair-step process, and you go from the busiest judge to the slowest judge. And there's not, you know, it's not an easy way to resolve that, other than you have to have some faith in the judiciary that we're splitting it around. When Cheyenne was so busy, I went down with and literally filled my truck of files to help out Cheyenne a few years ago. And I still help out Cheyenne, and Judge Edelman goes to Gillette regularly. So there's not a perfect process. This weighted caseload study is a good tool. It's not the end all tool. You could get a sense when they're asking for extra judges, and they keep repeating asking for extra judges. Rock Springs and Uintah County is the clear choice right now where we need another judge. It's not perfect, but it's not just a good old boy, powerful senator that gets it through. It helps, but it's a much broader process than that. It includes the Board of Judicial Policy, support of the District Court Conference, the workload study, other statistical analysis that goes through. So I think you're correct in wanting a systematic, objective way of doing it, but I caution you to not just rely solely on the workload study, because it has its limitations. And the challenge is when you give another judge to Rock Springs or Green River or Kemmer, it's going to skew it for a while, and they're going to be from the busiest place to the less busiest place for a while. We've seen that in particularly the smaller communities like I'm at in Sublette County. So thank you. I hope that answers your question.
Thank you, Judge Finn. Representative Gray.
Thank you, Madam Chairman. Trying to go quick here. I understand we're at time issues, but Judge Finn, thanks. It's good to have you here. We've been talking about this for a year and a half. So while you're here, I want to make sure to answer this, because we've had the Campbell County issue come before this committee. I've been on this committee a year and a half. We had it come before the committee 3 times. And when I look at the workload study, my response is, well, let's have the Johnson County judges help up in Campbell County. And so you're confirming, one, that you want to help, and 2, you are helping. But my other question is, you're willing to help more, right? And is there a procedure in place? I mean, how does that work? Does the judge just call you and say, hey, can you handle this case? And then you accept it? Or is, I guess, the Supreme Court, because of that statute we're talking about earlier, doesn't get involved? Is it just he calls you, or is there any improvement there? And is that working?
I think it's working. It's pretty ad hoc, like you say. Judge Edelman goes every other week for a day over in Campbell County, but usually it's a call. They say we need help. I'm now lucky in my stage. I like to take the big cases, and I take a lot of cases out of district that are the big ones that are sort of overwhelming a judge. We do have within our rules and our executive committee rules to do that as well. I don't know that is implemented very often. So we do have some rules to address that within our conference. Implementation of those rules and action on them, frankly, is not necessary from my view. And we have been very happy to try to help out. And sometimes that workload study represents that, and sometimes it doesn't. Judge Edelman doesn't get any credit for when he goes to Gillette, because he does all the child support hearings, and he doesn't get assigned to them. He just goes and does them. But he's spending about a 1/10 of his time in Campbell County helping out. So I think it's working. It's not perfect, but I sure don't want some a clerk in Cheyenne telling me now I have to pack up my bags and go to Rock Springs and help out for a while. So thank you.
All right, with that, public comment is closed on the bill. Committee discussion on the bill. Representative Pelkey.
Yeah, I'd like to make a motion to table the bill.
Moved by Representative Pelkey, seconded by Stith, or conversation by Representative Stith? Seconded by Representative Stith.
No, not seconded, sorry.
Is there a second? Representative Gray seconds the motion to table the bill. Discussion on the motion? Representative Pelkey, your hand is still raised. Do you want to discuss it?
Yeah, I just, I think that whatever we pass is going to be temporary. I respect the input from the Supreme Court, and let us hear what they have to say, see what kind of system we have in place before we end up mandating. So I just put a hold on it, and we can revisit the issue during the session, during the next year's interim. Well, not me, but you guys will be able to revisit that issue. It's just something that we need to keep tabs on. I don't think we need legislation.
Okay, further discussion on the motion? All right, all those in favor of tabling, Representative Stith? Let's move fast here. Hour and 15
No, I
minutes.
apologize. On just briefly on and against the motion, I think we need some structure, and I'm for the bill. So against the motion, for the bill.
Yeah, I would just like to provide further comments about the bill, and maybe it could just be as simple as the judiciary, I don't know that we need this either, but that the Joint Judiciary Committee will review every 4 years judicial workloads in the state. And we're not putting some kind of panicky precedent on agencies required to come up with reports or judges who are concerned that they're being controlled, but really just as a thoughtful measure to evaluate the workload and understand when legislation needs to be brought forth, and then we can reduce the number of bills each session, and legislators' time being spent with their local judges, determining whether or not new judges are needed, that it really is housed within that Joint Judiciary Committee, that's the process, instead of, Majority Floor Leader Dockstetter bringing a bill on Uintah County. He was at our first meeting wanting to know what we were going to do to solve that problem. We've heard from legislators in Campbell County. And so it really was kind of a consolidated effort to consolidate everyone's time without adding burdens to anyone other than the Joint Judiciary Committee and reviewing the topic meaningfully. So that's why the bill is there. It certainly needs work, but that's why it's there. So, I'm against the motion as well, just from that perspective, because I think we can work the bill and maybe even refine it without these unnecessary requirements on the court that may not be timely. So any further discussion? All those in favor of Representative Pelkey's motion to table the bill, roll call vote. Mary Beth. Representative Gray, you like to make a comment?
No, I was just raising my hand.
We're going to do roll call vote because we still got too many people.
Senator Anselmi Dalton.
No.
Senator Boner.
No.
Senator Cost.
No.
Senator Von Flater.
No.
Representative Burlingame.
Aye.
Representative Gray.
Aye.
Representative Jennings.
Aye.
Representative Pelkey.
Aye.
Representative Parnell.
Aye.
Representative Salazar.
Aye.
Representative Stith.
No.
Representative Walshett.
Aye.
Co-Chairman Kirkbride.
Aye.
Co-Chairman Nethercott.
No. And I didn't count that, Mary Beth, if you could tell me.
Six no's. The rest, yes.
Do we have a number on that? Yes. I think we have to record that.
I believe it's 8.
All right, 8 yes. All right, so committee back on the bill.
Madam Co-Chairman.
Mr. Co-Chairman?
So that was 8 votes to table the bill, correct?
Oh, it was. Oh, my mistake. I thought it was the opposite. So that motion has passed. The bill is done. All right,
Yes.
committee, we are at a unique break in the schedule. It's 12:20. We are way behind. Representative Burlingame.
Thank you. It'll be brief. Madam Chairwoman, can you remind me of interim rules? Do we have it's the majority of each house or is it the total of the joint?
The majority of each house. Mr. Fuller?
Yeah, Chairman Ellicott, Representative Burlingame. Every vote is just a majority of those present, except for votes to sponsor a bill, which would require a majority of each house then present. So this motion is just a straight majority of the committee.
Great. So we have 24 people in the waiting room, committee members. We do probably need to take a quick break here. Like yesterday, we're just going to do 30 minutes. To those of you waiting, our sincere apologies. We will come back in at 12:50 to get back on the schedule. I know that's a short time frame. So we'll see you at 12:50. Enjoy your lunch break.